Good morning, everybody. Let me know how I'm sounding, how I'm looking in the headphones and the audio and the video. It's your boy Perfect Timing Podcast in the building. Uh as you see from the title, as you see from uh the video that we already have up, we're waiting for Young Thug. Young Thug may be in the court right now. How I sound, everybody? Good morning, everybody watching. Hey, what's up, Uppercut? How you doing, bro? Salute, salute. We gonna chop it up too after the video. I got a poll up right now. I want y'all to vote. I don't mean to use that. I don't mean to use that vernacular. Do you think do you think Gunna cooperated? And then you can vote in the poll on whether or not you believe Gunna cooperated, and then let me know if you believe that you agree with Young Thug or Gunna cooperating. And now, before we start, Uppercut, anybody joining, we could discuss right now in the chat what y'all think is gonna happen. Do y'all think Young Thug? Okay, who is that? We got some movement from security. Do you guys think Young Thug is going to cop a plea today? Does anybody have any idea? So what we watching right here, right now, everybody, just so you know, we are live in Atlanta right now. This is 11 Alive Atlanta. Shout out to 11 Alive Atlanta. So this is live footage. We're going to discuss, and I'm going to show some footage of Gunna being released. We got some footage of Gunna being released. I'll go over that once this court hearing is done. I also got a video that I'm putting up now after this about of Young Gunna. Does anybody remember Young Gunna doing Crime Stoppers? Does anybody remember that? When Young Gunna's career first started, he had some pushback because he actually had cooperated with Atlanta police and the Atlanta DA previously in his career. So I have a video that I'm going to be posting on the channel. I have a short and I have a full video I'll be posting of Young Gunna when he cooperated with Crime Stoppers in Atlanta. I'm not saying that's good or bad. I'm not saying that's right or wrong. I'm just laying out a timeline here. And I want to discuss, give us an opportunity to discuss. Uppercut TV said he believes Young Thug is going to cop a plea today, and Uppercut TV is saying that Gunna most definitely is snitching. I don't like that term. We got to think of a better term, cooperating. You know what I'm saying? Because that's such a street vernacular, and we have to have better terminology on the Perfect Timing television network. So, you know, Gunna's cooperating with authorities. So we're gonna say he cooperating with authorities. You know what I'm saying? I know I got that in my poll, but we're gonna try to stay away from that type of language. You know what I'm saying? Because we don't want anybody to feel any type of way. You know, that actually came up in the Nipsey Hussle case as we're waiting on Jeffrey to enter the courtroom. That actually came up in the Nipsey Hussle case. What's up, KP? Pushing please, right? Pushing P for real. Gonna need to do a remix, huh? KP with them gems, man. KP from KC5. What's up with your brother? Thank you for coming in, man, King. Pushing P for real. Look out for the remix, man. Look out for the remix from Young Gunna, man. Crime Stoppers Incorporated, man. The remix to Pushing P. Pushing please, you know what I'm saying? It looked like they standing up, you know what I'm saying, and they swearing in the judge, you know what I'm saying? It's Lazo, by the way. Peace. Oh, what's up, Lazo? You changed your name. Salute, bro. Good to see you, bro. Good to see you. I ain't seen you in a minute. Okay, that's the judge. That's the judge. I don't got no volume. Is it me? I'm pretty sure my mic is working. Everything is working. I was just recording. My hopes is that they're just having us on mute. You know what I'm saying? So we waiting for them to come in and come off of mute, right? Salute to everybody. I hope and pray everybody having a good holiday season. You know, despite, you know, can we have joy for Gunna being home after what's taking place and what I mean, I don't want to get too much into it, right? But I want you guys to share your thoughts. Make sure you vote, share the show. You know, it's very important. I've been hearing a lot of YouTubers talk about things, and I know a lot of us got caught up in doing cash apps, but you know what's really important, you guys, for those who support the network, the television network, is to hit that share button. Develop your own network. It's a lot of YouTube content creators like Lazo. Lazo's in the building. Make sure y'all subscribe to Uppercut TV and this whole network and family. And what Lazo did, he brought me in and he shared me with that whole network, right? So I was able to grow. It's important that we hit the share button, right? To get this shit, to get our message out. KP from KC5, thank you, bro. Lazo said, just share. Gunna told the judge, sir, that's my rap name. I read 30 books a year, sir. Is that right? So after this, we're gonna show some more video because people right now, I don't know if everyone actually has seen Young Gunna in court. Because content creators tend to make money off of the speculation. But we got Young Gunna actually in court. You know what I'm saying? Gunna in court making this plea. And in court, he says, you know, he says that YSL is a gang, and in his statement, he says that he will not testify, right? But in court, he actually said that he will testify under oath. So that video is out. So we're gonna show that video. A young thug in court, and then well, not Young Thug, Gunna. We're waiting on Young Thug to come in court, but Gunna actually. So a lot of people have read the article. Okay, here we go. The judge is in court. What's up, man? We can't hear nothing. What's up, man? We can't hear nothing. ATL. We could keep chopping it up though, or what y'all think is going on. So Lazo said Gunna gonna cop a plea. I mean Thug gonna cop a plea. Gunna already copped a plea. Um, we reloading this to see what if we can get some audio here. At least we should hear some shuffling around. Yeah, still no audio. And we see she talking. This is Atlanta. You know, I'm gonna discuss this a little bit later, but I don't understand why we can't hear, why we're not being allowed to hear the discussion, but they're showing the video. All right, let me get back to the chat. What y'all got? Hey, Mrs. Perfect Timing in the building. Gunna singing like Beyonce, telling on everybody. So what? So Gunna was actually in court. Gunna entered what's called an Alfred plea, where he says that he admits guilt but maintains his innocence, right? And what he said in his actual statement is that he's not going to testify. But in court, under oath to the DA, he said, "Do you admit that you will testify if called? You can use the Fifth Amendment." He said, "Yeah, I will testify." "And you admit that YSL is a gang and needs to end?" "Yes, I admit YSL is a gang and needs to end." What the hell is going on with 11 Alive? Let's see if I can pick it up on another channel. The thing about it is gonna have
This holiday, master your kitchen with Wayfair. Don't let your fingers write a check that you
no, there's no audio. There's no audio, ladies. You guys probably already confirmed that. There's no audio. For some reason, there's no audio. So I don't know if they know that there's no audio, but there's no audio. But I'm sure we'll get playback. So uh, that's what a lot of people are saying, baby. A lot of people are saying that snitching. We saying cooperating. We saying cooperating. PTP, make sure you click on that share audio button when you sharing the screen. You might have that on audio. Yep. I checked everything, bro. So what I did is I opened up another window. So I got this playing on two windows, and there's no audio. So you guys could probably open it up on yourself on another window, but there's no audio. And as you heard that commercial that came in, we do have audio with the commercial, you know what I'm saying? But we don't have audio with this right here, which is unfortunate though. But so Gunna, baby, right before you came in, I was talking to the audience about the fact that I got a video that I'm uploading right before this went live. I was working on content for you guys of Gunna cooperating with Crime Stoppers, right? So if you guys recall, Gunna had already worked with the Atlanta DA. Gunna's already familiar with the Atlanta DA. He worked with the Atlanta DA in the past. He's cooperated with the Atlanta DA. He worked with Crime Stoppers. If you remember, Gunna did a 60-minute special where he talked about the pantry at the school. And even in that 60-minute special, he talked about cooperating with Crime Stoppers. So Gunna has a history of cooperating with the Atlanta District Attorney's Office and working with them in corroboration, right? So I believe that they always intended to use Gunna in his history of cooperation with the district attorney's office, right? So that's unfortunate, right? Because you got to understand when Jeffrey signed Gunna, like some people have been saying, who no one knew who Gunna was before signing the YSL. So it's unfortunate, but he had exhibited this type of behavior throughout his life. He's never been a street dude. He's never a quote unquote street dude, because that's new vernacular. I don't like that terminology either. I never use that term, but this is a term that people are familiar with. So Gunna's never been a street dude, right? He's always been an artist, as even in the Crime Stopper video, Gunna is. What's up, King? Seeing Red in the building. What's up, King? This is perfect timing. So Gunna has always been the type of individual to cooperate with authorities. You know what I'm saying? Man, hit the like, man. Make sure you vote in the poll and subscribe and share the video, man. So right now, what we're watching is live video, and for some reason, there is no audio. I double-checked on multiple platforms. There is no audio. It may be for legalities, but there is no audio right now. But we're watching live video in the courtroom of Young Thug back in court today after Gunna cops a plea. So that's what we're watching right now, and it's we got a poll up right now. I want everybody to vote and tell me what you think if Gunna is a snitch. And actually, after that, I want to find out what you believe. If you believe that Thug is going to cooperate today. So I want to know what y'all think. Do y'all think Thug is going to cop a plea today? What do you think happens today in court, right? So make sure you guys vote, subscribe, you know, and let's talk about it in the chat. You know what I'm saying? Let's have a talk. Now, we're going to keep talking about some other things after this video. So, you know, it looks like there's some argument going on. I have no Atlanta Live. Atlanta Live, do you know that you don't have no audio, Atlanta Live? What's cracking, Atlanta Live? Man, so what we're doing right now, we watching video because they don't have no audio. I don't know what they thinking right now, but yeah, man. What y'all thinking in the chat, man? Y'all thinking in the chat, man. So a lot of people have presenting a lot of things about this. So it's a couple things I want to discuss, but I want to hear what's going to happen here, right? Because I'm interested in happening here. One of the pushbacks I've been given in the comment section on some of the videos, who's been covering
5 naughty facts that'll make you ditch your shower routine.
Your loofah.
So the audio, so you hear the audio working, but I don't know what's going on with Atlanta Live. So one of the things I've been pushing back on is
covered in bacteria. All of that
one of the things I've been pushing back on is I've been pushing on back on the last thing that we heard on this case in this trial was the district attorney's
it's no sound.
The district attorney's office had lied. There's no sound, so I was just taking a fellow blogger. I just went to another blogger who's showing this live. There's no sound, everybody. So the last thing I remember about this case is that the district attorney had lied to get the warrant and the wiretap. So that's been my pushback, right? The last thing, this is another thing. So you hear Little Bootsy, you hear Gilly the Kid, you hear everybody talking about Gunna's plea bargain, right? So I'm wondering, how could they get this plea bargain without a ruling on whether or not the district attorney lied and forged the warrant and the wiretap? Now, if you guys watch my channel and watch my courtroom coverage, we did the best coverage of the Breonna Taylor case. When we covered the Breonna Taylor case, as you may know, the feds are now charging the police officers in the murder of the Breonna Taylor case. There was never charged any police officer in the Breonna Taylor case. Do you know why the feds are charging the police officers? Because they lied and forged the warrant. Because the NRA and individuals are pushing back on no-knock warrants. So the feds are charging the police on forging that no-knock warrant. Breonna Taylor never sold drugs. There was never drugs in her house. You hear academics and you hear his friend from Fresh and Fit, the Fed dude. I don't like that motherfucker, man. And they talking about all this shit as if the feds is innocent and tell and do shit right? Well, in that case, they lied. The police lied to get a warrant. And for people who grew up in the street, who had their doors kicked in and had police lie and forge arrests, they do that shit all the time. They just don't get caught. So in this case, in order to move forward with the YSL investigation, that the feds would not come in on the RICO, and they would not get a judge to sign the warrant in the wire, the DA, this rogue DA in Atlanta, forged the DA. Now, the Fed and academics was talking about how difficult it is to get the warrant, to get the wire, because it's violating your rights. We have a freedom of speech. You can't just record me, right? So she lied to get the warrant, to get the wire. That disavows the whole case. It should be case dismissed. The same thing happened in the Breonna Taylor case. They lied to get the no-knock warrant. Everybody to this day says that Breonna Taylor was sleeping with the drug dealer and had drugs in her house. The reason the feds are charging the police officers, because that was a lie, emphatically. They made that shit up to get the no-knock warrant. In the case of YSL and Young Gunna and Young Thug, the last thing we heard, because Young Gunna and Young Thug have some of the best attorneys in the country. They have some of the best attorneys in the country, and these attorneys were able to uncover, by going through meticulously every paper, every minuscule fact in this case, they found that the warrant was forged. And no judge ever signed the warrant, and they lied to get the wiretap. I want to know what happens with that. What's the ruling on them lying on the warrant? This whole thing has been a rogue district attorney. Now, academics had an interview yesterday with the lawyer who's on the Meg Thee Stallion case. And academics is being salacious. Number one, academics is not ADOS, FBA, Black, Indigenous, Indian, whatever you want to call it. Academics and Fed is not Black. They mama didn't smoke crack. They didn't grow up in the projects. They don't go to Mississippi for family reunions. They are first generation in America. Academics and Fed, Fresh and Fit are not Black. They benefit off the Black experience in the same way Adam from No Jumper, Adam from Adam 20, Adam, I'm gonna call him Adam 12. Stop calling that motherfucker Adam, now that motherfucker Adam 12, because he the motherfucking police. That motherfucker Adam 12, because he the motherfucking police. academics and fresh and fit fed benefit off of black culture without being black, so they don't see the things that's happening in this case with this black judge and a black district attorney who could not get the feds to come in on this RICO charge. Now, last night when academics was interviewing a lawyer, the lawyer at the end of the interview when discussing the YSL RICO indictment said this district attorney has played dirty pool. The way she has gone about getting a plea out of young Gunna, it is reminiscent of Rikers Island. It is reminiscent of Khalif Browder and Meek Mill. Wait, see, look, it was a bad connection. So
what's important is that
we got audio.
It's a pretrial statute. That's not to be confused with 17-5-54, which is a return of property after a trial. So the reason that the 17-530 statute is particularly important is that, and I'll read it for you all. I know you all probably know this, but just so it's in the record. A defendant aggrieved by unlawful search and seizure may move the court for the return of property in the possession of which is not otherwise unlawful. So that means, of course, if it's contraband, other drugs, weapons, or other things that wouldn't ordinarily be subject to being returned. And to suppress as evidence anything obtained on the grounds that the search and seizure without a warrant was illegal, or the search and seizure with a warrant was illegal because the warrant is insufficient on its face, there wasn't probable cause for the issuance of the warrant, or the warrant was illegally executed. The motion shall be in writing, which that one was. State facts showing the search and seizure were unlawful, which it was. The judge shall receive evidence outside the presence of the jury on any issue of fact necessary to determine the motion, and then the burden of proving that the search and seizure were unlawful shall be on the state. If the motion is granted, the property shall be restored unless otherwise subject to lawful detention. Lawful detention would be contraband, of course, and it shall not be admissible, mandatory, shall not be admissible in evidence against the movement in any trial. The motion shall be made only before a court with jurisdiction to try the offense. If a criminal accusation is filed or an indictment or special presentment is returned by a grand jury, the motion shall be made only before the court which the accusation, indictment, or special presentment is filed and pending. The last time that we were in court, the court, Mr. Steele, I think we admitted for the court's consideration D1 through 10. Within those documents was the order Judge Newkirk entered. Can I have those, Christine? Do you have those? Do you have those ones? Are they up here? Okay, hold on a second. Okay, hold on. No, thank you. All right. All right, D1 was the accusation that was filed in this case, and that was related to the possession of marijuana charge. D2 was the motion to suppress any and all evidence located from the defendant's home. D3 was the supplemental motion to suppress any and all evidence located from the defendant's home. D4 was the order granting supplemental motion to suppress any and all evidence. And it reads as follows. After hearing testimony, a stipulation of testimony, and argument from the parties on Monday, April the 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from the defendant's home. Based on this ruling, the evidence located in defendant Williams' home is subject to the above referenced accusation number 16 SC.
Let's go. Let's go. We were just talking about that 5.0. No one else is discussing this. I'm listening to the other bloggers right now. No one else is discussing this 5.0. They can suppress evidence. Everything in your dog home. Gunna did not have this fucking snitch like that. Let's go 5.0.
There was a motion for reconsideration that was filed,
the best coverage of this shit. Let's go.
Or accepted by the clerk's office on the 20th of April of 2017. There was an order, that was D5. D6 is there was an order by Judge Newkirk entered on the 24th of April 2017. The order It reads as follows: the court, having read and considered the state's motion for reconsideration, the same is hereby denied. D7 is a motion for null pros on the same case where Mr. Steele filed a request to have the accusation null pros. D8 is the dismissal for want of prosecution. When the case was called for trial, the state was unable to proceed, and Judge Newkirk has the following reason: the motion to suppress was granted, and he granted the motion to suppress, and that was the 3rd of April, 2017. There is a exhibit from our last hearing on the 17th, D9, which is a letter that was written by Mr. Steele to Mr. Charlie Bailey, Esquire, May 17th of 2018. Read: the state of Georgia versus Jeffrey Williams, accusation 16 SC 1444444. Dear Mr. Bailey, I hope all is well with you and your family. I'm writing you to pursuant to my representation of Mr. Jeffrey Williams in the above referenced case. As known, the Honorable Court suppressed all the evidence in the case, was null pros, and prosecution is ceased. Mr. Williams has been attempting to obtain his property that is lawfully his concerning the above referenced case. The City of Atlanta is not releasing the same, as they still have the same marked as evidence, according to Mr. Williams' father. Could you please assist in having the property released to the lawful possession of Mr. Williams or his designee? Please call upon receipt to discuss the above. I look forward to speaking with you soon. Signed, sincerely, Brian Steele. Copies to the two Williams, one being the defendant, one being the senior, his father. D10 is these warrant for search and seizure. And those were the 10 exhibits that were admitted for the court's consideration on the motion on the 17th of November. So the court's concern is that while you all, the state that is, think that Judge Newkirk just specifically excluded the marijuana, he did, but the legal premise behind it would be fruit of the poisonous tree. Anything that was taken in that house at that point in time would be subject to being suppressed. And that's the first thing I'm going to let you all address. The second thing that would be of note is that under 17-5-30, this property was requested to be returned. And the statute's pretty clear: shall not be used in a future criminal prosecution. That is different than the return of property statute during trial 17-5-54. So yeah, that's why I preface this. I've had an opportunity to take a look at Judge Newkirk's transcript, which will also be included for purpose of record, is the next court exhibit from the 3rd of April of 2017. So with that, Ms. Love, what say you and your colleagues?
Yes, Your Honor. First of all, Your Honor, understanding the court's review of the transcript, I want to point out that in ruling on evidence that pertained to the possession of marijuana charge that Mr. Williams faced in that indictment, the court specifically, during the course of the proceedings, clarified during an exchange with the prosecutor, he is only seeking to suppress the marijuana.
I agree with you that, but the legal premise would still hold on anything that was taken in that home by a search warrant. You had an arrest warrant issue, and then you had a search warrant issue. So if Mr. Steele challenged the arrest to begin with, the warrant or copies of the arrest warrant and the warrant under Baez, versus the state, which is a 206 Georgia 552, which he cited at that point in time. That would make it so that anything else in the house that was taken would have been subject to being suppressed. Mr. Steele amended his motion. He asked for everything
They having audio problems, but we not. We still in the building, everybody. Shout out, gang. It's 5.0, 5.0, 5.0, simulcasting live on 3 channels right now. We on Perfect Timing Podcast, TV network, change the name, Perfect Timing Podcast Live, and we on Facebook under Patrick Potter. Don't miss me on Instagram, perfect_timing_podcast. They having audio issues, but we not. We in the building, everybody. Who told you first about this suppression issue? Who told you first about the falsified warrant? Who told you first about Gunna didn't have to snitch? Now do the math, everybody. Do the math. Now you add up what I said about the fact that they kept Gunna in too long. The Khalif Browder case, the Meek Mill case, Meek Mill on probation for 19 years. Rikers Island, where they hold people for 3 years without going to trial. Khalif Browder killed himself because he was on Rikers Island and he was innocent. He never went to trial. During that expose, they showed a man who was on Rikers Island for damn near 7 years. They came to him after 7 years and said, you get to go home today, but you got to say you're guilty. He did the same thing to Gunna, a multi-millionaire. After 7 months, they came to him and said, you get to go home today, but you got to say you're guilty. Who would not say I'm going to go home today? This is slavery. I don't care if you call it snitching. I call it slavery. This is not what Kyle Rittenhouse got, everybody. This is not what Kyle Rittenhouse got, everybody. Do y'all remember the Kyle Rittenhouse case? Somebody said the other day that they've been with me since the Kyle Rittenhouse case. Since Dante got murdered by that police officer and she got 1 year. They said they've been watching me since I've been doing the Ahmaud Arbery case. Well, this is not what Kyle Rittenhouse got. Kyle Rittenhouse murdered someone on camera. I'm going to say it again. I'm going to say it 2 more times. Kyle Rittenhouse murdered someone on camera. Kyle Rittenhouse killed a man on camera, and the judge would not allow them to call him a murderer. They would not allow the people that he called, that he killed, innocent or anything, because they were criminals in the past. Kyle Rittenhouse got a presumption of innocence. Jeffrey and Kitchens, Williams and Kitchens have not gotten the presumptions of innocence. I'm going to go to R. Kelly, did not get a presumption of innocence. Bill Cosby did not get a presumption of innocence. If Bill Cosby would have got a presumption of innocence, we would have not have got 3 trials in the Bill Cosby case. 3 trials in the Bill Cosby case, and then Bill Cosby got to come home. How many times have they tried R. Kelly, and they did not give R. Kelly bail? R. Kelly had not had reoffended. What you don't know about the R. Kelly case is they tried him on acts that happened 20 years ago. That means R. Kelly should have been able to be free, just like Kitchens and Williams, make music, make money, and put on the best possible defense. Whether you think R. Kelly was guilty or not, whether you think Jeffrey was guilty or not, they deserve bail. They deserve a presumption of innocence. They should have been able to make music, make money, and put on the best defense possible. And I wager this. This is my wager. If Jeffrey would have been able, and Kitchens would have got bail and been able to make music and make money, they would have lost. The state would have been able, when forced by this lawyer, by this great attorney who turned up that the god darn warrant was falsified, this case would have been thrown out. I said this case never would have got this far. This is what happens when you are FBA, ADOS, black, indigenous, or whatever in America, and that's what academics and fresh and fit, fair ass miss. And that's what's wrong with them being a voice in this space, because they not black, they not ADOS, they not FBA. They don't go to Mississippi on the summertime for family reunion. You don't go to Mississippi in the summertime for family reunion. You didn't sell crack, you didn't smoke crack. Fed, you was an FBI agent. You look at black people different. You don't understand the Ronald Reagan story. I grew up in California where Ronald Reagan was a governor, where they created crack cocaine to do a secret war. And they hooked people like my mother, rest in peace, to crack cocaine. Fuck you, Fresh and Fit. Fuck you, academics. Fuck you, Fed. You don't know shit about my life. Don't talk that shit about being a Fed. Don't talk that shit about crack in America. Don't talk that shit about black culture is crime culture. Academics bitch ass said black culture is crime culture. You gonna talk about that shit without talking about Ronald Reagan, without talking about crack, without talking about Oliver North, without talking about the Iran Contras, without talking about Freeway Ricky Ross, without talking about Pablo Escobar. How you gonna say black culture is crime culture? This is the same Pookie narrative that we have to deal with, brothers. Because see, Pookie represents 6% of black men. See, this is why they're so happy that we no longer have Kevin Samuels as a voice, because academics and Fresh and Fit wouldn't be able to say the things that they say if Kevin Samuels still was alive. Rest in peace to Kevin Samuels. Over 50% of black men make over $50,000 a year, are unwed, and don't have children. See, academics, when he says black culture is crime culture, it's the same thing that black women are doing when they talk about all black men ain't shit. See, they think the 6% of Pookie represent the 96 percentile of black men and black people. If black women, academics, I challenge your statement. If black women are the most educated segment of women in the country, then how can you say black culture is crime culture? That was racist. So Kanye West faces vitriol for his statements, but academics gets to say out loud that black culture is crime culture. Show me where black culture is crime culture. Steadily, the crime statistics has gone down drastically since the 90s. This is why they got defund the police. Crime has steadily gone down. Crime has steadily gone down. Academics, you cannot defend the statement that black culture is crime culture. That is absolutely ridiculous and racist to say black culture is crime culture. I'm not gonna fucking accept it. We not gonna accept it at 5.0. They having audio problems, but I'm not having audio problems. You know why they went to mute? Let me cut my camera on. You know why they went to mute? You know why they went to mute? You know why they went to mute? Because God is good, man. Because God is good, because 5.0 is the greatest. They went to mute because 5.0 is the greatest. They went to mute because 5.0 is the greatest. See, G.O.D. wanted to show everybody the greatness of 5.0 and Perfect Timing Podcast Television Network. There's a certain perspective. I don't go live all the time. Y'all can see my channel is growing. I don't have a need to go live. I go live when God calls me. I want to say God bless to everybody in the chat. A prayer covering over you during this holiday season. May you be safe, blessed, and covered. Because during this time, you would think people would be nice, but they not. They meaner than ever during this time, right? So I pray covering all of my 5.0 audience. I went live today to give a perspective that academics who has the controlling narrative is missing because he's not black, FBA, ADOS, indigenous. Academics is a piece of shit racist. Academics and Fresh and Fit Fed miss. When academics was interviewing, this is the point that I missed about Khalif Broader and Rikers Island. When academics, because I got interrupted because we went live, academics was interviewing the lawyer Mo Gant. And Mo Gant said this was fucked up. Mo Gant said this was dirty on the district attorney. And academics did not give it credence. Academics, your racist bias did not give Mo Gant, who's actually attorney, his opinion credence when he said the district attorney has kept Kitchens incarcerated too long. If she didn't think that he was actually a criminal and a threat to society, he had a right to bail, academics. He had a right to bail. He should have been freed, and he had the ability to put on the best defense possible. Young Thug, as we see now, they falsified the warrant. See, the Fed, Fresh and Fit, both of you guys are biased and racist because you're not black. The Fed talked about how he would get information on someone having dope in the car. Well, what if that information came from a baby mama or ex-girlfriend who just wanted to get you fucked with? The same thing could be true with the Young Thug raid. And now they are in a position to blow the whole case. They had to get Gunna. So now we see why Young Thug is in court. He's not copping the plea. Everybody thought he was copping the plea off the top. They're not copping the plea. He has some of the best attorneys in the country. Gunna jump ship. Woo! Hey, shout out to my brother Radiology. I have a theme on this channel. I call it God, I just pray for everybody. I have a theme on this channel. I grew up in the church. I grew up spiritual. And God told me one day, trouble the water, because my channel wasn't growing. It wasn't moving in the direction that I wanted to. Look at Jeffrey. God told me, trouble the water. So I did. I troubled the water. And everybody, see, the thing about troubling the water is, as a captain of the ship, this is my ship. As a captain of the vessel, God has given me a mission in the voyage. I have a manifest, right? I have a ship manifest. As a king, as a captain, he's given me a ship. My microphone, my audio, my Wi-Fi, he's giving me a ship, an audience, a captain, a stewardship. I have a manifest. So motherfuckers on this boat gotta be ship shape. Everybody on the boat, 5.0, 5.0, 5.0. Everybody gotta be ship shape. We gotta have real sail. We back with the audio.
Thank you, now. Okay, all right, Mr. Steele, sorry about that. Okay, so I do have the transcript from April the 3rd of 2017 with, and I've labeled it as...
Woo! They had to stop me. That's the devil. I was about to start preaching. I'm not gonna stop preaching. 5.0, 5.0 in the building. I had to trouble the water. Jeffrey had to trouble the water because Gunna was in ship shape. As soon as there was a little bit of waves, 7 months, Gunna jumped off the boat. Gunna jumped off the boat. Gunna was in ship shape. Gunna wasn't ready for the storm, everybody. Gunna wasn't ready for the storm, everybody. Let's go.
2018 case that the Honorable Prosecutor has cited to this court. It's in Division 3 that the prosecution is relying upon, and it is wholly inapposite to what we're dealing with here. What we're dealing with here in Court's Exhibit number 2, which is the transcript from April 3, 2017, has nothing to do with what happened in Alford. In Alford, Mr. Alford is a passenger in a vehicle. The car gets stopped. Law enforcement officers see open containers and they smell marijuana as they approach the car. The officers then ask Mr. Alford, is that your backpack at your feet? And the answer is yes. And there's contraband, there's drugs inside the backpack. Mr. Alford is arrested and he's prosecuted for that. The Honorable Trial Court had a pretrial motion to suppress. And the state of Georgia was on notice that Mr. Alford, just like the Honorable Mr. Williams, challenged the actual arrest. And the state of Georgia did not bring in a certified copy of a county ordinance saying that you can't have a person can't have an open container in a car. Because of that, the trial court granted the motion to suppress. The state of Georgia appealed. What happened in the Court of Appeals was as follows. The Court of Appeals said, that's exactly right. Without introducing the certified copy of the county ordinance, there was no arrest for that purpose. But what the court then went on to hold is, however, when law enforcement officers lawfully walked up to the car, they smelled marijuana. And the odor of marijuana in the state of Georgia is a reason, probable cause, to search the car under the automobile exception. And because the automobile exception kicked in, it didn't matter that there was no certified copy of the county ordinance, and the Honorable Court of Appeals of Georgia found that the odor of marijuana was sufficient probable cause. The police then could search the car under the automobile exception. The backpack then, therefore, should be searched. The contraband inside the backpack should not. In Court's Exhibit number 2, so Alford is like a waste, respectful, I don't mean to be rude. It is just not even close to what we have here.
Can I hijack for just a second, Mr. Steele?
Of course.
We're going backwards. We should be going forwards. That, I agree with you with at the status of your hearing in front of Judge Newkirk. the issues involving the search warrant, the arrest warrant, the search warrant, and these issues would have been, it's a snapshot in time. Since you filed another motion to suppress, the state now is willing to at least present forth evidence to show that the arrest warrant, the search warrant, and the seizure of these particular items, that there is a basis, because we've gone forward and it's another case. So can you address that for me? Because I don't believe that I have to kind of look at it from my foxhole, because this evidence is related to, you filed a motion to suppress in this case. So I can't rely totally upon what Judge Newkirk has indicated. And also, this case was never appealed, so there's no really appellate ruling on this issue. So I would argue it's ripe to consider again.
I would respectfully disagree. I wish I could do that in every case that I don't win, that I can come in and do a second bite at the apple. This is the exact
But it's a
issue.
different case.
No, so then the state can I win a motion to
No,
suppress?
it's a different case. Okay, it's a different case. That was just a possession of marijuana case. This is a RICO case, and this is they're arguing at this point in time, since you filed another motion to suppress.
Who's the lawyer? Are y'all following this? He's arguing on behalf of the state. This is my exact point with Kyle Rittenhouse. The judge in Kyle Rittenhouse was impartial and made the state had to fulfill the burden. Who the fuck is the DA?
It's a final.
Let's go.
Do
y'all see the bias in the right?
It doesn't matter. It can go up to the appellate court. And it is the same issue that's already been litigated between the same parties, Mr. Williams and the state of Georgia. They're still the state of Georgia. It is res judicata and it is collateral estoppel, and all that is in my motion to suppress. Also, it is not accurate to say that Judge Newkirk did not consider fruit of the poisonous tree. Judge Newkirk considered the following. My motions, which are in front of the court, the original motion and the supplemental motion, challenges everything that was taken from Mr. Williams' home.
Your motion to suppress is D2, and your supplemental motion is D3.
And it challenges everything that was done because the police unlawfully, as found by the Honorable Judge Newkirk, entered Mr. Williams' home. So what happens at our hearing, specifically at transcript.
Woo! Unlawfully entered the home, everything. Let's go. I want this attorney, everybody.
So
Turn up, share the show.
Of the lead officer.
I'm with you.
Specifically, starting at line 5, or line 3. The answer is, yes, sir, I do believe there was an arrest warrant. I interrupted. I didn't mean to interrupt, but I interrupted. I said, I didn't mean to cut you off. The answer continues. That is what the warrant was for. Yes, sir. Then my question is, and that warrant was from a long time before. If you know, and if you don't know, we can get the information through someone else. Answer, I don't know the exact actual. I then asked, were you aware the warrant or the case was eventually dismissed? Answer, I'm not certain, sir. My question, so law enforcement officers do not have a search warrant, though at that time, this is simply an arrest warrant. Answer, correct. On page 33, which is what the state is trying to hijack, to use your word, Your Honor, this motions transcript and wrongly mislead the parties on what it says. The trial court, Honorable Judge Newkirk, on line 14 states, all right, no other evidence, brief argument. The Honorable Mr. Bailey, then District Attorney in Fulton County, said, Your Honor, the defendant has filed this motion through his attorney, Mr. Steele, challenging while seeking to suppress evidence in this case that was collected from Mr. Williams' home at the time. The basis of this motion is, and the Honorable Court interrupts, the only thing he's challenging is marijuana, which is what the state seeks. Mr. Bailey says on line 23, right. The basis of the motion, thank you, Judge, the basis of this motion is essentially that in the motion filed by the defense, that law enforcement officers did not have the right to enter the home did not have the right to enter the home to effect the warrant. Going down.
Coffin nail.
On page 34.
Coffin nail.
Mr. Bailey, the district
Coffin
attorney.
nail.
Interrupt you a second.
Of course.
Yeah, you better interrupt, Judge. Who's the DA?
Zoom link is only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry, continue.
That's okay.
I apologize.
On page 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entry in Mr. Williams' home. Then there are two parts here, and that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant, and what did they see once they got inside that would rise to probable cause? Then skipping, Your Honor, to line 21, same page 34. This is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went in home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said, it's at the end of line 1, Your Honor, or it's the middle of line 1. An arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to effect the arrest warrant. And then we get to the second point, and it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom. And Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appealed. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A plus game and try to win before this court. That's not the way, I don't get to do that, ever.
But it wasn't appealed. I mean, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by you within 30 days of the entry of the order.
Why would I appeal it?
Well, I know you wouldn't appeal it, but.
And the state doesn't appeal it. What does that mean? It becomes final. The court cannot amend that order. You'd be amending the finding between the same parties on the same exact issue. They don't get the second, in the case law, it says second bite at the apple. Then, Your Honor, on page 38, line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs. That is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me an opportunity to speak. I said, thank you, Your Honor.
He
Your
is
Honor,
kicking
we are
ass.
traveling
Let's
under-
go.
I'm assuming the court has
Let's
it.
go.
It's not a glitching copy. There was a
Coffin nail on top of
supplement to
coffin
motion
nail. They
suppress,
had
and
no
this one
right to
stressing
enter the home.
so,
They should have got
Honorable Judge
a
Lambo,
warrant.
any and
And these are
all
black police
evidence
officers, black district
located-
attorney, black judge. Let's go. Are y'all following this? Are y'all
And I
following
stress
this?
this, Your Honor, all evidence must be suppressed. It is not the way you're being told by the Honorable District Attorney's Office. This was not about, oh, the judge only suppressed marijuana. That is just patently a intellectually incorrect way to interpret this. On page 39 of that same transcript, line 25, I continue. First, 1, there is no certified copy or any copy of an arrest warrant in DeKalb County under Baez, which the court already spelled B-A-E-Z versus state. And then we get into that arrest warrant. And then I say on page 40, Your Honor, line 10 in the middle, is that if there is no arrest warrant, the police entry into, and I said, appellant's home was unlawful and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1. Mr. Williams demanded in paragraph 7 of the supplemental motion and challenge that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is Gaither, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said right, period. So my issue before this honorable court is the first entry obviously without the arrest warrant at this hearing is unlawful, then the second can't be saved by the second entry either, because that would be without lawful blessing, same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting line 4, I continued. But then when the court goes through and looks at the search warrant itself, the only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about. And I challenged that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. One, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there, and so they could go into the house and get him? That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the 2 issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion, which the court filed does not have. What
A little bit, another audio issue. Are they gonna come right back? Do y'all understand what's happening here? He's reading court transcript from a trial he's already won. When I started off, I said, what happened to the motion to suppress? He already won it.
And that is
This judge is making him
the
read.
supplemental one. Again, he's not challenging
word,
the
True?
arrest in
What's
this
the
case.
word?
He mentions
Relitigate.
something in
Making
there
him
about the cab arrest
relitigate
warrant.
arguments
If
he's
he
already
wants, there's no
won.
need to
Let's
challenge
go,
the cab
5.0.
arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of court's number 2, the district attorney states on line 6, that doesn't mean that because there's not a certified copy of that arrest warrant that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line 51.
51, okay.
Yes, sir.
Yep.
And then on line, the court asked me for a summation on Baez again, and I said, okay, that's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant. And just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone or standing on its own. And I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home. And thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again plead to the Honorable Judge Newkirk, the law should be followed in this case. And I say, but I guess it goes back to if the first arrest warrant is not before this honorable court, according to Baez, it was challenged, just like I challenged it on behalf of Mr. Williams, then how can this court sit here, the evidence that you heard, and say, well, there's a valid arrest warrant? We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home. Because now, you know, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue. So I don't know how law enforcement without a valid arrest warrant here today has any evidence to go before the court. And that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential source, the murder of Mr. Thomas, because all of that doesn't save the search warrant. So that's why I thought it was important. The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows. All right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything, so that might have been harmless, excuse me. That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side. So I will grant your motion, Mr. Steele, if you will prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this honorable court with as much earnest and power and professionalism as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the
Let's go! Let's go!
He is
We ain't helping you.
Our constitutional rights.
Let's go 5.0.
And the state
Throw it out,
doesn't get
Judge.
to go back.
We
and do
already
it
won
again.
a motion to
Then
suppress.
Judge Newkirk's order.
Is this
If you look
America?
at his order,
Black
Councilman
judge, black district
He does
attorney,
not just
black police
suppress
officers.
marijuana. The
What is
prosecution
happening, ladies and
they're great
gentlemen?
people.
Let me know
But on
your
page
view in the
33
comments.
is all they want you to do, Your Honor. They want you to be in your foxhole and just focus with tunnel vision and say when the judge said all he's challenging is the marijuana and act like, well, that's all there was. The judge found that the entry was unlawful. We don't get to do it again. And Mr. Williams then tried for a year and a year to get back his property. And what did the police do? They tell him, it's the evidence. We're not giving it to you. The statute says it. And now today the state wants to come in and say, well, we had another search warrant. I will talk about that search warrant in a moment. Let me just show you, if you don't mind, the order of the Honorable Judge Newkirk, which I forget the number.
It is D4.
And Your Honor,
That's the first one.
thank you, sir. And it's entitled, it's filed, I know the hearing was on the
The
3rd of
DA,
April,
the DA is getting a thorough butt whooping today, ladies and gentlemen.
So D4, order
The DA is
granting
getting a thorough
supplemental
butt
motion
whipping today, ladies and
suppress.
gentlemen. He is
And I'm
whooping
stressing
the
it,
district
any
attorney's
and
butt.
all evidence
in court, in
located
public.
from
Let's go.
defendant- Excuse me. It's Mr. Williams' home. It says it's used defendant's home. After hearing testimony, a stipulation of testimony, an argument from the parties on Monday, April 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. There is nothing clearer in the world.
That's a coffin nail, ladies and gentlemen. That's a coffin nail, ladies and gentlemen.
Intellectually not being straight. Based on this ruling, meaning everything's gone, the evidence located in Mr. Williams' home that is subject to this accusation. That's all. The accusation was just a marijuana case. Specifically, just over an ounce of marijuana is hereby suppressed and cannot be used in evidence by the prosecution in the trial of defendant Williams. Do you know where the judge got that language from? I know I didn't do this order because I would always say the honorable court. This is just not the way I'd write an order. But you know where the court did get the language of what the state wants to rely on, specifically just over an ounce of marijuana? It's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this honorable court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed and it's in your court's file. I believe it's defendant's number 10. I'm going to tell this honorable court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams devices when they won't give it back to him. They won't restore it to Mr. Williams or his father, who had a power of attorney. They go to Cellbrite, and Cellbrite now has better.
They having audio problems, but we not. 5.0 radio in the building. Perfect Timing Podcast, television in the building. Thousands of views every day. Make sure you subscribe and check out my shorts, my live reactions. We simulcasting live via StreamYard on 3 channels right now. Perfect Timing Podcast Television Network, Perfect Timing Podcast Live. I'm also live on Facebook under Patrick Potter. That's PatrickPodder. Check me out live on Facebook Live in the building. I'm also on Instagram at perfect_timing_podcast. Make sure you follow me on all social media outlets. You can check me out, Mrs. Perfect Timing, under Perfect Timing Podcast on Twitter and on TikTok with the Rick Rock. The audio gonna be coming back any second. What he's explaining is he's already won the motion to suppress. He's already litigated this into a superior court. We back!
The legislature then says that the last 3 lines of this code section, Your Honor, any search warrant not executed within 10 days from the time of issuance shall be void.
Oh, this is good. Sorry.
Void, ladies and gentlemen. He said void. Perfect Timing Podcast in the building. Make sure you hit the subscribe, share, like, and hook a brother up. It's the HBU special.
Okay, go ahead, sir. (17-5-25), the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his stolen, the property they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal and say, break into the devices. I mean, what are we doing here? And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even had to ask for it. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that case matters to this. They had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question. And I think, I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Mr. Rosenhaus?
Coffin nail, coffin nail, coffin nail. And again, I like to reiterate,
Your Honor,
this is a second bite at the apple.
I
He's
know Mr.
already
Steele
won this
has an
argument.
interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I mean, I look at the way it's capped, its style and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean,
So, Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law. I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was
She's
no
not
ruling
a judge.
on fruit of the poisonous
You understand
tree.
what I'm saying? What's
We're not
happening here?
talking about
She's not proving her
second bite of the
case.
apple here.
The burden, it
We're
is. The
talking
burden is on you,
about
and she's refusing to
him now
prove.
challenging a search warrant that was not challenged before. And I
he
think
did though. That's the thing about it. I mean, I think it's clear from the reading of the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything. The arrest warrant, the search warrant.
That's the second time he said it.
And
That's the second time, ladies and gentlemen. That's not my audio. That's Atlanta's audio again. That's the second time he said that he has challenged everything, and he successfully challenged everything.
Those things are fruit of the poisonous tree, or at a minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and Your Honor finds that.
So I don't know what's going on, ladies and gentlemen. I don't know why we having these audio issues in Atlanta. They can't keep the Zoom going. You know, they maybe need to hire me to do their audio and visual. 5.0, 5.0, 5.0. They can't run a goddamn, they can't run a prosecution, or they can't run a Zoom. Let's go.
Because we didn't get to that hurdle. So this is at page 55 through 56. The Judge Newkirk says it doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't.
It's almost like they purposely distorting the audio because she ain't got nothing to say to defend the argument. Do you guys truly? Let me turn it down a little bit. So they fix the audio. Do we understand in the 5.0 audience what's happening here? This attorney, which is one of the best attorneys in the country, this is the thing you got to be careful about, Atlanta, with the black judge, with the black DA, with the black police officers. These attorneys work for law firms that have reputations that precede them throughout the country and throughout the globe, right? You cannot bring this man with his reputation that's beyond Young Thug at this point. You cannot bring this man before your court and his law firm and then make him relitigate an argument that he's already won successfully. It would be different if it was from the gate, but he's already successfully argued the suppression. This is what I started my podcast with. Somebody give me my props in the chat.
The poisonous tree, and Your Honor, the just.
This is what I started my podcast with. This is what if you go to academics right now, you guys, if you go to academics, when he was on there with Fresh and Fit, you will find my comment. It's a very respectful comment. And what I do is I push back on academics and I push back on Fresh and Fit based on this suppression issue. And what I'm saying is, young Gunna jumped the ship too soon.
For everything.
Come on, y'all get your audio together.
To show as to the 2016 cell phone warrant. We're ready to do that today. Now, Your Honor, there has just been absolutely no ruling as fruits of the poisonous tree. And if the court were to find.
All right, that mean they're going to fix their audio. Usually when they do that, the audio comes back. I don't know what's going on in Atlanta, but y'all need some help with your IT department. Now, like I said before, 5.0 would be happy to help you. Okay, the courtroom has lost the audio. I'm speculating what's going on with the audio because so I need to explain what's happening here. So what's happening here, I started my podcast, and like I said, if you go to academics interview with the FBI agent, I talked about this suppression issue. I started my podcast focused on the suppression issue, right? So what I said was, how can I politely said in the comment section of academics, and I asked Fed to give me an answer on what do you think happens or should happen going forward in the case, taking into account the suppression issue. I also asked them to add in the fact that the lawyer that academics interviewed, I think his name is Mo Gant, said that it was dirty pool to keep Gunna and Young Thug incarcerated when they did not believe that they were violent criminals. They both had a right. I shouldn't say deserve bail. I should say Young Gunna and Thug had a right to bail. See, there is a law that says you have a right to a speedy trial. If you guys remember,
right.
Okay, we're back with the audio.
Except
We
as
back.
provided in 17.555 or 17.556 subsections D, E, and F, and it goes on to say, when a final verdict and judgment is entered in finding the defendant guilty of the commission of a crime, any personal property used in evidence in the trial shall be returned to the rightful owner. All personal property in the custody of a law enforcement agency, including personal property used as evidence in a criminal trial, which is unclaimed after a period of 90 days following its seizure or following a final verdict and judgment in the case of property used as evidence, which is no longer needed in a criminal investigation or for evidentiary purposes in accordance with 17-5-55 or 56 shall be subject to disposition by a law enforcement agency. So this one is different than 17.530, which is pre-trial. So this is trial evidence, or what we do with evidence after the trial of the case. So that, and I mean, I still have an issue of that because you would have still had to return property to him.
Your Honor, I'm sorry. I have to respectfully disagree with the court here. It's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says that would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling at a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor, not.
But you You took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, that's not otherwise illegal, is returned. The 17.530 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and there was no ruling as to fruits of the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm going to take 5 minutes, okay?
Thank you, Your Honor.
Okay. All right. We're going to be in recess for about 5 minutes. Okay.
What y'all think, ladies and gentlemen? This is Perfect Timing Podcast. Thank y'all for tuning in. I believe they are donezo on this one, man. Shout out to everybody watching right now. Make sure y'all hit the like, share, and subscribe button. This is amazing right now. This is like better than court TV. I mean, who saw these turns coming? I mean, I got a poll up now. Let's check the stats on the poll. Who would have thought that this would be the direction that this would go this morning? I even myself would have assumed that Jeffrey may come in and take a plea. I didn't want him to. I've been arguing the whole time that this was a rogue district attorney. This judge is being forced. This is the first time this judge is being forced to give him the presumption of innocence, right? And to treat him impartially like he is an innocent person, an innocent human being. Number one, based on this, he should be out on bail. Do you guys understand that they won a motion to suppress evidence? The police never should have entered the home. If that's true, at the very least, Jeffrey should be out on bail. I'm not saying that they should throw out the case, but what I've argued with academics in this comment section, what I've said to my audience here today, that our rights as Black men are violated in courtrooms most times. And Kyle Rittenhouse had a presumption of innocence, even though a man died on camera. Jeffrey and young Gunna should have been allowed bail. I'm sorry, that's wrong. That's not correct. I'm wrong. That's wrong. That's not the right terminology. Jeffrey, Young Gunna, aka Young Gunna, and Kitchens, Jeffrey, aka Young Thug, and Kitchens, aka Young Gunna, had a right to bail and a right to speedy trial. Do you guys understand what I'm saying? They had a right to bail and a right to speedy trial. Their rights have been violated by not granting them bail. This is my issue with academics right now. I gave academics pushback because academics interviewed a lawyer named Mo Grant last night. And Mo Grant said that the district attorney was wrong for keeping young Gunna incarcerated for longer than that she would want to keep him incarcerated for the crime. The same thing is true with Khalif Browder in Rikers Island, where he committed suicide. Rikers Island were a place with a whole young Black man for years who should have a presumption of innocence, who haven't gone to trial. And you know what happens? A lot of Black men who are on Rikers Island, I call it modern slavery. Everybody, let's just say what it is. It's modern slavery. What's happening on Rikers Island, what's happened to Young Thug and Gunna. It's modern slavery. You have Black men on Rikers Island for up to 3 years at a time who've never gone to trial, who by law, by the Constitution, should have a presumption of innocence, right? And you know what they do to these Black men who are innocent 90% of the time? They come to them after 3 years being incarcerated, never getting bail, and they say to them, you get to go home today, but you have to sign a piece of paper saying you're guilty. And the Black man may say, but I didn't commit the crime. Do you want to go to trial? Because if you go to trial, you got to stay incarcerated, and you got to go with a public defender that works for the district attorney, and the district attorney is offering you a deal. Trust me, you don't want to go to trial. It doesn't matter if you're innocent. You want to go home. Do you want to go home? Yes, I want to go home. So Rikers Island, this is what Meek Mill and Jay-Z, I thought this is what Meek Mill and Jay-Z was all about. Why haven't we heard Meek Mill and Jay-Z say anything about the trial and the lack of bail opportunity for Gunna, Kitchens, and Jeffrey Young Thug? Because that's what the whole Meek Mill case was about. Meek Mill was on probation too long where it became slavery. And again, in the Meek Mill case, it was a black female judge. In this case, we have a black female district attorney, we have black judge, and we have black police officers who are violating these young black millionaires' rights and constitution. That part is being left out by academics and Fresh and Fit because they don't understand the nuances. They don't understand the nuances. They're not comparing this case to Kyle Rittenhouse, where a man died on camera, but the judge forced the burden on the state, and they weren't allowed to pivot and call Kyle Rittenhouse a criminal during the trial. Kyle Rittenhouse had a presumption of innocence, and he was found innocent. Jeffrey, aka Young Thug, has not had a presumption of innocence this entire time. He should have been allowed. I'm sorry, I keep saying that. He had a right to bail. He should be free, making music, making money, being able to put on the best defense possible. Now, if he had been free and he was able to make money and manage his label, then this case, I believe, would have been thrown out because he would have been having millions of dollars to pay lawyers. And this suppression issue alone would have been in the media because he could have paid the media, made a song about the way this rogue district attorney has lied and made up a false RICO case. He wasn't able to put on an adequate defense because he was unlawfully not granted bail. This is what academics miss. And this is what the lawyer Mo Grant was trying to tell you, academics. This is the biggest part of the trial. You have to go back to Rikers Island. You have to go back to Meek Mill. You have to go back to Jay-Z. I don't see how you missed the opportunity to fuck with Meek Mill. You love fucking with Meek Mill. What happened to Meek Mill's initiative? What happened to Jay-Z and Meek Mill working with the prisons? Where's Kim Kardashian? Because no one truly understands what it is to be a black man in America and articulate black issues, black male, ADOS, FBA, indigenous, Indian issues. That's why I went live today. This ain't about hip hop. You know, a lot of people say, I'm not going to talk about Young Thug. I'm not going to talk about, it's not about hip hop. Whenever I do a trial, it's always about more than what the average individual, that's why my name is perfect. That's why I have the perfect perspective. Whenever I do trial coverage, you guys have to go deeper, read in between the lines, see what's not being said. It's not about it's about a greater issue we're having with the black community and black mental health. What's happening with all of these cases where you have black women going after black men, and we refuse. Dr. Umar scraped at it, but with Meg Thee Stallion and Kelsey and Tory Lanez and all of these cases, what you have is you have some undealt with trauma. And now you have an issue where Meg Thee Stallion may end up going to prison because she held on to a lie too long. Meg Thee Stallion lied to Gayle King about sleeping with Tory Lanez. She lied to prosecutors. She lied to police. Right now, I have a beautiful playlist up. All my 5.0 audience, remember, when I did the show about Tory Lanez versus Meg Thee Stallion, where my thumbnail at? When I did the show about Tory Lanez versus Meg Thee Stallion, I said all of the things that's coming out now. I said all the things that's coming out now. Everything I said is coming out now is true. She waited 30 days. She waited 30 days before she changed her story to where all physical evidence is gone, right? And now what's happening is her best friend is recanting on the story that she put forth. It's because the best friend got immunity because she understood. It's the same thing that happened in the Deshaun Watson trial. They had 60 people accuse Deshaun Watson, but when it came down to a grand jury and putting those same women and those accusations on the court, and you had to swear on oath, all those women ran. And when it came down to Kelsey going to court and swearing on the Bible that Tory Lanez did something that he didn't do, she wasn't willing to do it. And I think it was because she didn't have the same amount of skin in the game that Meg Thee Stallion did. Meg Thee Stallion is trying to say that Tory Lanez's career grew after the event, when we all know that Meg Thee Stallion had no career before this. And now, because we got this issue that we not being honest about, this young lady might go to prison. We're not dealing with the fact that in the Meek Mill case, these were black police, black district attorney, black female judge, 19 years kept them as a slave. The same thing is happening in Atlanta. I've always questioned the style of this RICO and why the feds never came in with the RICO. Now we understand they never had a case. Now we know why the feds never came in. This was always a rogue district attorney with a personal vendetta. Her goal was to break YSL as a company. YSL cannot be proven as a gang until young Gunna said what he said. It's absurd. If YSL is a gang, don't forget everybody. Don't forget everybody. If YSL is a gang, Liar Cohen, who's the head of YouTube that we're on right now, thank you, Liar Cohen, who created 300 with the guy from Def Jam, is co-owner of YSL. Liar Cohen. Liar Cohen is the one who gave Jeffrey the imprint. I remember the video when he first got the YSL offices at 300. So if YSL is a gang and not a record label given to him by the head of YouTube, see, it never made sense to me from the beginning. Then why haven't you indicted Liar Cohen, the head of YouTube? And do you know what Gunna just did? Liar Cohen is on the phone with Gunna right now, cussing him the fuck out. After 7 months, you're going to tell them motherfuckers that YSL is a gang? You don't even own YSL, motherfucker. You work for YSL. Who the fuck is Gunna to say that YSL is a gang? Fuck you, Gunna. Liar Cohen is on the phone with Gunna right now. Who the fuck are you to say YSL is a gang? I created YSL. I gifted it to Jeffrey. He called Jeffrey his son, just like Baby called Lil Wayne his son. Y'all remember Liar Cohen when Jeffrey wore the dress, when he was on the horse? He gave him YSL. He gave Young Thug YSL. Young Thug turned it into something. But he gave Young Thug, I remember when he gave Young Thug YSL. So if Gunna testifies that YSL is a gang, where's the rest of the motherfuckers to the district attorney of Atlanta? Where's the indictment for Jack Harlow? Where's the indictment, for Liar Cohen? Where's the indictment for YouTube? I'm just asking. The same is applicable for the Brittany Renner story. If Brittany Griner gets to get out for marijuana, then the 40,000 or is it 4,000? I can't recall. It don't matter. But all of the black men who are incarcerated in America for marijuana should be released. And all of the people who still have penalties from the draconian 1993 crime bill, who the president is in office right now, should be repealed. The crime bill. Hey, Trump, you want the vote? Hey, Trump, you want the black man vote? Repeal the crime bill. I'm going to tell Donald Trump right now, Donald Trump, you want my vote? Repeal the crime bill. Every black man got to come home for marijuana. Every black man got to come home for marijuana. There's something going on in the judicial system that allowed this rogue district attorney to do what she's doing. They fake. My podcast today started with the falsified warrant. That's because the Fresh and Fit Fed said how difficult it is to get a warrant, to get a wire, to get all this shit. And I said, and has anybody heard the judgment on the warrant? So here today is the first time I've heard what happened with the suppression issue. And the Atlanta district attorney is trying to overturn another judge's judgment. This judge ain't gonna do it because the district attorney is not a judge, don't have the reputation on the line. This judge would have to agree with this lady who did not effectively argue her point, right? How you gonna go to dinner and go to the country club this weekend and say you gave her this win and she didn't effectively argue a point? She don't even have the case law on hand. She should have had the case law on hand. He's not gonna give her a win. She did not prove her point. Furthermore, this lawyer this is his friend. Young Thug's lawyer is the judge's friend. They go to the same country club. He is a respectable, honorable lawyer throughout the country. This man just said to him, I already successfully argued this suppression. And another judge higher than you, who's both of our friend, already granted me suppression. Huh? If you know, you know. If you know, you know. He said another judge higher than you, who's our friend, already granted me the suppression. For you to listen to what she's saying today is giving her a second bite at the apple because another judge, our friend, already agreed that they did not have a right to go in the house and they have to suppress all the evidence and give him back the devices. What do they have to give back, ladies and gentlemen? Everybody, what is this argument over? Cell phones and laptops. They have to give back cell phones and laptops. Back to the wire, fresh and fit fed. Back to the wire, fresh and fit fed. Because if you have to give back the cell phone and the laptops, I'm now going to question, like he said, the bad fruit. This is why they're so arguing so fervently. Help me out with that word. You know what I'm saying? You know I got dyslexica. But that's why I got lactose intolerant. That's why the district attorney is arguing so fervently, because the bad fruit is going to apply to everything. You can't keep that wire. You can't keep that wire. And if you want to keep the wire, you can't keep nothing that's negative to my client because it's bad fruit. And if we go to trial, which I'm going to suggest to my client that we go to trial, the problem is now I can interject what, ladies and gentlemen? What can they interject now because of this falsified warrant and the lack of returning the evidence? They can interject reasonable doubt. Because remember, ladies and gentlemen, Jeffrey should have had, and he has a right to a presumption of innocence. You have to, as a juror, presume, because everybody would say, well, he's not going to go. Academics would say he's not going to go to trial. It's not a federal indictment, academics. The feds refuse to come in. So now he's been able to interject reasonable doubt. And he has been able to dirty the waters of the prosecution. So any potential juror, you have to look at a dirty investigation, a dirty investigator, and you're going to have to judge on whether or not their dirty tactics, their illegal tactics was worth it. Was it worth it? Was it worth violating these young men's rights, arresting 28 fathers? Because Jeffrey himself committed not one violent act. And they've been selective on who they've indicted. Because like I said, Jeffrey was gifted YSL by the head of YouTube. So if YSL is a gang, is the head of YouTube a gang leader? Is that too far-fetched to suspect that? It goes back to the Jeff Bezos in the movie. Jeff Bezos is still selling that movie. We don't have to say the name of the movie. We don't have to say the name of the guy and all the shit. But I'm just saying to you that Jeff Bezos never stopped selling that movie. He started selling it for more money. It goes back to the Clippers. The owner of the Clippers who made those derogatory terms about indigenous FBA ADOS people who bought the Clippers for $15 million, sold it for $3 billion, he was rewarded. Y'all following me, y'all? He already successfully argued the suppression. What I love about today is we didn't move forward on whether or not Thug would make a plea. So let's say now, check this out, everybody. Listen to this. Let's say now young Thug is willing to make a plea. After he wins this argument and suppresses 80 to 90% of the evidence against him, what do you have on me? A weed charge. I'll plead guilty to the marijuana. I've already been in jail damn near a year. Y'all hear what I'm saying? Once this, because look, everything doesn't go away, right? Gunna pled guilty. Once he successfully argues his suppression, the judge is going to come back, he's going to win. There will be another plea. Because now you can't get me on RICO racketeering despite what Gunna, the Crime Stopper, said. You can't apply it to me, just like you can't apply it to Lyra Cohen, right? So now we talking to something else. I will plead to the marijuana. What you want me to plead to? My lawyer, who's one of the best lawyers in the country, my lawyer's so good. You're gonna be with penguins in Alaska. What Tony Montana say? Somebody help me out. I watched that shit every day as a child. My lawyer, you know what? I got a great lawyer. My lawyer's so good. You're gonna be in fucking Alaska with the fucking penguins. Imagine as we watch this argument here today, and he's taking a lot longer than 5 minutes, everybody. He's taking a lot longer than 5 minutes. You know why? Because he is fucked up. They work in conjunction. The district attorney and his judge have been working in conjunction. You know who he's talking to right now? He's talking to that district attorney who did the press conference, everybody. Do y'all understand what's, it's one office. It's one office, ladies and gentlemen. Right now, there is an intent. Oh, shit! Oh, I'm the best at this shit, 5.0, 5.0. I'm killing this shit, perfect timing, and you killing this shit, boy. There is an intense discussion going on right now, ladies and gentlemen. You're not going to get this coverage from no other podcaster because they don't have the intellect. Academics is biased and racist. SCO, Paperwork Party, all of them is too stupid. They're too fucking stupid. I don't know if it's the marijuana. I don't know what it is about them motherfuckers, but they too stupid. The only person presenting you these arguments in this perspective is Perfect Timing Podcast. Everybody was wrong. You know what everybody was wrong on? Takeoff. Let's go back to Takeoff. Like, I've been wanting to get on the panel and talk about Takeoff because, again, the Takeoff issue, again, is not about Takeoff. It's about a greater issue with mental health in the Black community. That what people missed about Takeoff, and look, I was proved correct about Takeoff with the DJ Pat because this was my backstory on what happened to Takeoff. Migos was over, and the Migos no longer had a home at QC Management, at QC Music Group. Offset had got beat up by 4PF, and Offset had got jumped by Lil Baby. Offset felt away by the lack of support from the label and the rest of the Migos camp. I got this information from the reports that Offset was beat up and jumped by 4PF. Lil Baby was asked in the interview, is there a beef with 4PF and Migos? Lil Baby said no, but when Offset went solo weeks before Takeoff's murder, Lil Baby and P are on video laughing, making fun of Offset. Offset says, I haven't, back to P in an Instagram message, I haven't been to QC in 2 years. The Migos have been over. The same thing happened with Snoop Dogg on Death Row. It was dangerous for the Migos in Atlanta. What we're learning with all of this is that there was a war in Atlanta. You just heard about another indictment with Slaughter Gang, Why 21 Savage? This goes back to WAC 100 saying 21 Savage has cooperated on a level that we don't have knowledge of. So now we hear that the person was a member of YSL and Slaughter Gang. So what we need to understand is that there was an actual turf war going on in Atlanta. People were actually getting murdered. YFN, YSL, Playboy Cardi, Future. There was a war going on in Atlanta. People were dying. You need protection as a rap artist. Rap artists are dying everywhere, right? Young Dolph, everywhere. You're not safe as a rap artist. Migos had the protection of QC. They're a big label. P is a street dude. But now P has aligned himself with 4PF and Baby and disaligned himself with Migos. Now, if you take into account this mathematics that I'm presenting to you, you might say to yourself, what the fuck was Quavo and Takeoff doing in Texas? And people are stupid enough to think they went there for a party. That is another CEO. And you are in contractual issues with your current CEO. You are not going to be around another powerful CEO for a party. That's not why Quavo went to Texas to be around Jazz. He went to Texas to be around Jazz because if I leave QC, where can I go? I don't have a Cardi B to protect me. This is what he's saying to Offset. What I'm supposed to do, bro? You left the group. Now, the public doesn't know Offset left the group. Offset says, I'm going to do my solo album and I'm going to do my contractual last 2 Migos albums to let people know the Migos is over. I want to go solo. I'm only going to do 2 more Migos albums. Now, P and QC as a label, and when Offset leaves, this is where the contention is coming even more with P and Migos. Because now Offset has told the whole public, basically the Migos is dead. The Migos is dead. Offset told the whole public, I'm going solo, but I'm only going to do 2 more albums, which is all we have left on QC. Nobody knew that the Migos only had 2 albums left on QC. So now you see the video of Messi with Quavo in the video with the Migos contract and the gun. Quavo is the owner of Migos. Quavo doesn't want out of the Migos. He owns the Migos. The Migos is the Beatles of the rap. Their catalog is worth a lot of money, right? Quavo wants his imprint, the Migos, off of QC. But if he leaves, he could potentially get murdered, right? For his catalog, because rappers are being murdered for their catalog, and he owns a piece of the Migos, right? So he needs protection. Quavo can't just go anywhere if he leaves P and QC, even though it's contention going on up at the label. He might be pissed. He might be like, Offset, you started this shit. It's your fault, Offset. Be that as it may, it doesn't matter who started it. P is rocking with Baby and 4PF. He's hee-heeing and ha-haing at Offset. Quavo goes to Texas. Now, keep in mind, when this is occurring, Takeoff is alive. The argument with QC and Offset, Takeoff is alive. We're learning all of this about the breakup between the Migos and QC as a record label. The breakup with Migos is not just the Offset Quavo thing with Swahili, is not just a breakup of the Migos, it's a breakup of Migos and the label, ladies and gentlemen. So if you understand my theory from the whole time, it was CEO shit. This was label and label. This was Mob Ties and QC. This is Death Row and No Limit. This was a big play for No Limit to get Snoop Dogg. This would be a big play for Mob Ties to get Quavo. Quavo would move from Atlanta and Mob Ties would provide protection, and Mob Ties has the influence to get Quavo out of his QC contracts, get Migos as an imprint, and put Quavo out as a solo album. Now, think about this. Cactus Jack, remember Cactus Jack? And Travis Scott is already canceled. Quavo and Travis Scott do another Cactus Jack album under Mob Ties. You launch Travis Scott and Quavo under Mob Ties, and now you have another big record company. This was going to be a big play. It was going to be a big play to bring Quavo to Mob Ties. Something went wrong. I said that from the beginning. Now, I haven't speculated to what. But when DJ Pat was arrested for the murder and not Migo Bands, then now you understand. Because I said everybody discredited that black girl who said it wasn't about a dice game. The argument started in Fifth Ward. It was about something much more intimate. You know what else that black girl said? She said that the only people who had guns was junior people. That means DJ Pat was one of the junior people. Not only Little Cam, see the way the Texas niggas who got the narrative in the blogs are reporting to Charleston White, all these niggas is from the South. They're not giving you a real perspective like I'm giving you. The black girl said it wasn't about a dice game. Now think about what the Houston PD is saying. The Houston PD, because just like in this case, the Houston PD has to present a narrative when they go to trial of how Takeoff was murdered. The Houston PD said it was about a dice game. The black girl who should be evidence said it wasn't about a dice game. I was with them for the whole couple days. It was about something deeper, and it started in the Fifth Ward. Nobody has questioned her, has investigated what she meant by that. What was it about? If it wasn't about a dice game, see, you're not going to hear from her because that goes against police narrative. It's the same thing that's happening in a YSL case. That's why I'm bringing it up. You're not going to hear from that black woman again because it's easy to discredit black women. And it goes against police narrative. When she says it wasn't about a dice game, you got to ask why. She said only people who had guns was junior people. And now we found out that Junior followed DJ Pat. DJ Pat was there as an affiliate of Junior and Mob Ties. That's why Migo Bands had his guns out, because he knew it was a hit, because he knew the deal didn't work out that they came there to make. They didn't come there for no party. They came there for the same reason Snoop went to Master P and Death Row. They needed protection, and they needed freedom from QC. No one has presented my perspective. It's the same thing that's going on with YSL. I'm the only one that presented the perspective of the suppression and the evidence, and now I'm being made right. The rest of DJ Pat makes my theory the most plausible theory on the internet today. The arrest of DJ Pat makes my theory the most plausible theory on the internet today. What I use for an example for everybody listening who might be OG like me is Death Row. Snoop was the biggest thing in the world. He was the biggest celebrity, not just the biggest artist. He's still one of the biggest celebrities, not just one of the biggest rappers. Snoop fell out with Death Row and Suge when Tupac came. If y'all remember, Tupac and Suge was teasing Snoop in the same way that P was teasing Offset. P and Little Baby was teasing Offset. Remember? Tupac was calling Snoop a punk and all this shit, and they were literally trying to kill Snoop. Does anybody remember this about Death Row? They were literally trying to kill Snoop. Suge had police on the payroll. Snoop had to get out of LA. If you hear Master P tell the story, he says Snoopy was in trouble. He needed our protection. He needed our help. And Master P knew by signing Snoop, he would have to deal with Suge and Death Row. But he took the chance. And Snoop needed protection. And Master P and Louisiana provided protection from him. It was a university for him. Right? Now he owns Death Row. But for sure at that time, we are very thankful that we still got Snoop. Because if it was up to Suge, just like with Takeoff, Snoop would not be here right now. And Suge would own his catalog. Some of the biggest records in hip-hop history, Doggy Style, all that shit. Snoop, and it would be worth more because just like Pac, with Snoop being dead and murdered, that shit was skyrocketing and listening and sales and everything. Suge would own that. The reason that didn't happen is because Master P protected him. My argument is that Quavo, because he had ownership of Migos, and because there was a breakup of the Migos and a breakup of the Migos and QC, the label, Quavo needed protection. And he needed off the label. He went to somebody he thought could protect him, a strong person. Jazz, J Prince, Mob Ties. P ain't gonna fuck with y'all. Get me off this label. My solo album been sitting. He been focusing on Little Baby. Little Baby on his third album. I ain't got my first solo album. Listen to Quavo. Huh? Little Baby on his third album. I ain't got my first solo album. Remember what I said about Offset. I said all three Migos members had received solo deals in the millions. How do I know that? Because when they got into the beef, Offset said I paid P back millions of dollars to get out of my solo deal. Why would Offset have to pay P back millions of dollars to get out of a solo deal? Because P and QC as a label advanced Offset and each of the Migos members millions of dollars on their solo projects. But they were not putting out the solo projects. They barely promoted the last Migos album. That was Quavo's issue. That's why Quavo had the gun in the Migos contract. How could all the bloggers miss that? How could all the bloggers miss that Quavo in the Messy video with the gun and the Migos contract is about P and QC? The Migos contract is with P and QC. All of the bloggers, to make money, to get clicks, are avoiding the real thing with Quavo. And why he has the gun and the contract in the Messy video, why is Quavo hanging around Jazz? There's issues with QC, and no one has talked about that. But another thing to my argument is, look at the lack of communication from P and QC since the murder. Salute to Deborah Carr, salute to Dark Green, salute to Sirism, salute to J Doe, salute to the whole 5.0. Look at the lack of support of P and QC, the lack of vocalness of P and QC and Coach K since the murder. You know why? Because there was contention. The best thing to do now is be quiet so people don't start investigating and listening to me. That you were in a beef with Offset. Days before Takeoff's murder, there's video of you and Little Baby laughing at Offset, and you tried to steal Offset's masters contractually, trying to take Offset to court, and Cardi B had to emasculate Offset, come online and say, I paid the millions of dollars to get Offset off of his solo deal. This is what was happening days before the murder. See, this is the context that the other bloggers have not brought to you. Days before the murder, there was an internal fight in QC. Cardi B, who's also signed to QC, interjected, and now Cardi B's threatening to leave QC. This is big shit. Cardi B's the biggest artist. Her and Gorilla got the #1 song. That's going to be nominated again. Her and Gorilla got a #1 song that's going to be nominated for a Grammy again. And she's associated with QC, the label. And now she's upset. She wants to leave QC and her husband wants to leave QC. This is how somebody gets murdered. This is a lot of money. We're talking about Cardi B. We're talking about Offset. We're talking about QC's. We're talking about Migos catalog. Another thing that I said in my other videos is that QC is a $1 billion record company, similar to Death Row. Now, remember the story? Remember the story, y'all? Gucci Mane went to prison. Migos, Young Thug, what's the other nigga? Rich Homie Quan, everybody was signed to Gucci Mane. P is Gucci Mane's associate from the street. P is a street dude. When Gucci Mane goes to prison, Gucci Mane, P is transitioning his street money into the record companies, just like Master P and everybody did, right? Gucci Mane asked P to take Migos and all of these artists and do the record company thing while he go to prison. I'm not saying this to put P down. I'm saying this to establish context and a timeline so that you understand that P went from an associate of Gucci Mane, a street associate of Gucci Mane, to a billionaire CEO of a record company in a matter of a short period of time. I'm telling you that because just like Suge Knight, my argument is neither one of these young men were prepared for the $1 billion status. They weren't prepared to be owners and managers of a $1 billion record company and manage multiple artists who are the biggest artists in the world. Suge Knight had Tupac and Snoop. P and QC had Migos and Little Baby. He was now a billionaire. He's having issues with women. He's in the press, getting women pregnant. He has all this money. He never intended to be this successful. He has $1 billion at his disposal, right? He's signing Cardi B. He has the biggest celebrities in the world. I propose to you that P was not ready to manage these entities. And that's what happened. And QC fell apart. And the same thing that happened at Death Row is QC became a haven for 4PF, and the Crip gang. 4PF and Little Baby are Crips. Just like on Death Row, Suge was a Blood, and Death Row became a haven for the Bloods. Snoop was a Crip, and they no longer felt safe going up to Death Row. Nate Dogg said, "I never went to Death Row without a gun." In the movie, you see them beating up people, all this stuff. And Dre saying, "You have to stop doing this, we too rich." And Dre leaving because Suge didn't know what to do with the money and the power. He brought the gang back around. He had police officers who were Bloods, and that's what led to the demise of Death Row. Because this person who was a street dude became a billionaire, and he did it. He deserves the accolades for his business acumen with the contracts. Even today, Snoop gives him his props. P deserves his props for what he did with QC. He got off of 300. P and Coach K was on 300. This goes back to YSL. Do you understand what I'm saying? 300 gave YSL a label. 300. I believe Coach K works for 300. It's so much to this story. I mean, I feel like I'm the only one that's like really like a real reporter who's done real research and who really cares when they talk to you guys about what really happened. Do you guys realize how we have QC and how we have YSL? It's relevant to today. We have QC, we have YSL because of the head of YouTube, who helped create Def Jam and Run DMC with Russell Simmons. His name is Lyle Cohen. Noriega had him on the Drink Champs podcast, gave him his props. He's been in hip hop for a long time. He's been coming up a lot of memes and the talks about the way contracts and record labels manipulate the black culture. Same way talking about academics today. He started a label after Def Jam. He started his own label, Emperor. He knew what was going to happen with the internet. I remember him talking about the creation of 300. Right? I remember when he created 300, he had, I think, T Grizzly. He had a lot of people on 300. He had been trying to get 300 going for a minute. And he had Young Thug. He put the bank behind Young Thug. Young Thug turned out to be a great artist and blew it up for 300, right? He granted, and then he also had the Migos, right? Now, Coach K worked for 300. Now, Coach K and P, now remember what I told you about Gucci Mane and P. Coach K gets with P, who must have had the money from the streets to create QC, Quality Control Music. Lyle gives them an imprint. So QC and the Migos that he got from Gucci Mane is on 300. How many people knew that? YSL and QC both come from 300. Now, what I'm trying to tell you is I give Coach K and P props because they got off 300, right? They got off 300 and then they were able to be successful as of their own imprint. They take Migos and they turn QC into a $1 billion company with Migos, Cardi B, and then they land a new artist named Little Baby. So I give who's the biggest artist right now. So P deserves his props for what he did with QC. He and Coach K. But I'm not taking away from them. But you guys have to look at the facts that I brought out today. No one has brought up, they just keep saying, Little Cam. Because I think they say Little Cam because I think they believe Little Cam triggers the algorithm. Little Cam. Little Cam has nothing to do with this. This is a contractual issue between labels and CEOs. That's what this has all been about for all the bloggers. DJ Pat, Little Cam. They sound stupid, bro. No one has brought up the fact that there was a rift on the label QC. Yo, they are all the way down in Atlanta, y'all. Remember what I said to y'all? I said the reason why they're taking so long, remember this was supposed to be 5 minutes. This was supposed to be 5 minutes. The video never came back. The judge came in the court and left. They already argued the suppression. Do y'all know the severity of what's happening now? This is the entire case. That's why Jeffrey came in smiling. Y'all thought Jeffrey was going to plead because Gunna said what he said. Jeffrey came in the court smiling. They haven't came back because of the severity of this argument. This is their whole entire case. This judge is back there with the district attorney, and the district attorney is trying to pressure him to let the evidence in. And he is saying, no, you're not taking my reputation. I've helped you far enough. I am not helping you anymore. Background music too loud. Want to hear what you talking about? I got background music on. Do I got background? Maybe earlier, do I got background music on? 5 minutes. Maybe earlier I had some background. I had some background issues. I just now looked at the chat. Baby, I think we getting the flu. We've been getting sick, man. Everybody, kids been sick. My son been sick. My daughter been sick. I think we getting the flu, man. I think we getting the flu. So think about this, y'all. Thank you, Deborah. Think about this, y'all. This should have been very simple. He said 5 minutes. He should have came right back. We should be watching the video. Something else was playing. Something else was playing. All right, y'all. I'm going to stop presenting this and I'm going to show y'all something else. Academics was going for a minute. I'm about to go for a minute, man. I ain't did a live stream in a minute, man. Y'all hit the Cash App, man, because ain't nobody presenting this. Y'all see the $ Big D Rants, man. Hit the Cash App, man. I'm going to show y'all something else, man. Shout out to City Nash, man. City Nash, City from Sacramento. Bay Area boy. Bay boy. Where is it at? So shout out to City Nash, another blogger who'll be presenting this shit. He'll be having a good perspective. You know what I'm saying? You know what I love about YouTube and the bloggers and everything? Everybody is unique. Everybody's unique and they got their own perspective. You know what I'm saying? So, man, I need y'all to hit the like, share, and subscribe, man. This right here, fair use. Let me throw my fair use banner. This right here, fair use, is from the podcaster, City Nash. Shout out to City Nash. Fair use. Great blogger. Go ahead and subscribe to him, y'all. So he was the first one to break this story. So give him his props and give him a subscribe. Check this out, y'all. Check this out. This is Young Gunna yesterday, because Young Gunna put out a statement. Now, this is going to contradict Young Gunna's statement. Remember what y'all have heard so far on Young Gunna. Young Gunna said, I'm not going to testify. I'm not going to do this. I'm not going to do that. I'm not going to snitch. I'm not going to tell. Shout out to everybody 5.0 who's watching. Young Gunna, you saw it here first. Perfect Timing Podcast 5.0, 5.0. Check it out. Shout out to City Nash.
Whether or not you agree or acknowledge that statements are true, okay?
Yes, ma'am.
I became affiliated with YSL around 2016. Is that true as it pertains to you, Mr. Kitchens?
Yes, ma'am.
YSL is a music label and a game, And you have personal knowledge that members or associates of YSL have committed crimes in furtherance of the gang.
Yes, ma'am.
You were present when law enforcement officers stopped a vehicle in which you were present along with Jeffrey Williams, wherein hydrocodone, methamphetamines, and a firearm were recovered. These items did not belong to you.
Yes, ma'am.
And do you acknowledge the following statement? I recognize, accept, and deeply regret that my talent and music indirectly furthered YSL the gang to the detriment of my community. YSL as a gang must end. Is that your statement or acknowledgement?
Yes.
2 gang members have been sentenced to life without parole for a deadly armed robbery at a DeKalb County gas station. A jury found Cordarius Dorsey and Quintavious Jackson guilty for shooting and killing a husband and father of 6. It happened in 2019 at a gas station.
Statements are true, okay?
Yes, ma'am.
I became affiliated with YSL around 2016. Is that true as it pertains to you, Mr. Kitchens?
Yes, ma'am.
YSL is a music label and a gang, and you have personal knowledge that members or associates of YSL have committed crimes in furtherance of the gang.
Yes, ma'am.
You were present when law enforcement officers stopped a vehicle in which you were present along with Jeffrey Williams, wherein hydrocodone, methamphetamines, and a firearm were recovered. These items did not belong to you.
Yes, ma'am.
And do you acknowledge the following statement? I recognize, accept, and deeply regret that my talent and music indirectly furthered YSL the gang to the detriment of my community. YSL as a gang must end. Is that your statement or acknowledgement?
Yes.
2 gang members have been sentenced.
That's some cold game right there. That's some cold game right there. Shout out to City Nash, everybody. That's some cold game right there. Just for everybody speculating on what happened in court with young Gunna before he was released. You know what I'm saying? You know, because if you read the reports, if you listen to academics, it kind of contradicts what Gunna just said in court. If you read the report on on the Shade Room and TMZ, Gunna says, "I'm not going to take the stand." He's taking the stand right there. He's taking the oath right there. Gunna says he's not going to admit anything. He just admitted under oath that YSL is a gang and it needs to stop. He also admitted and he promised that part of his that he would testify if necessary. He would testify if necessary. I got more. Let's see if they back. They back, but I don't hear nothing. I see Jeffrey. Y'all want to go back to that? Let's go back. They back, but I don't hear nothing. Let's go back. They just showed Jeffrey. He's trying to see what's going on. You know, he hasn't gotten a fair trial this whole time, man. It's disgusting. It's disgusting.
Yeah, it's all. Yes.
Your Honor, what the state would like to put in as the warrant for search and seizure, an affidavit for search warrant. These are already D10.
Yeah, they're in D10, madam.
Yes. We have 2 more.
The arrest warrant out of DeKalb County that I challenged. The state would like to introduce this. That's already attached and in with the state's motion for reconsideration. I can't remember what number it is right now.
Your Honor, we just ask if we could just admit it as a separate exhibit to this hearing. It's certified. It's self-authenticating.
Well, it's already in evidence. And the last one is already in.
Well, any objection to that one, the search warrant, arrest warrant, I should say, Mr. Steele.
I will lodge an objection at this point. Yes, sir.
Basis?
Basis is that it is.
Yeah, it's all. Yes.
Your Honor, what the state would like to put in as the warrant for search and seizure, an affidavit for search warrant. These are already D10.
Yeah, they're in D10, madam.
Yes, we have two more.
The arrest warrant out of DeKalb County that I challenged. The state would like to introduce this. That's already attached and in with the state's motion for reconsideration. I can't remember what number it is right now.
Your Honor, we just asked if we could just admit it as a separate exhibit to this hearing. It's certified, it's self-authenticating.
Well, it's already in evidence. And the last one is already in.
Well, any objection to that one, that, the search warrant, I mean, arrest warrant, I should say, Mr. Steele.
I will lodge an objection at this point. Yes, sir.
Basis?
Basis is that it is attempting to relitigate something that should have been done before. It has no bearing on this motion whatsoever.
Your Honor, we would like a complete record, and if it's already, as Mr. Steele says in the record, we don't see the harm in simply perfecting the record with a self-authenticating document.
Well, the issue is you didn't introduce it at the hearing in 2017. That was the basis for the ruling for Judge Newkirk. So I don't see why I would need to accept it right now. I mean, because I'm going to rely upon Judge Newkirk's ruling.
We just like to have it in the record, so we may use it if we, just to complete the record, Your Honor, not for the purposes of argument in this particular instance. Should the court wish to rule with us and have a hearing on this, then we'd enter it separately, but for the purpose of the record, we'd seek to introduce it right now.
Let me see it, please.
Yes, Your Honor. It's certified.
All right, Mr. Steele, I'm going to admit over your objection, okay? It states one for purpose of the motion.
And Your Honor, then we'd also just move to admit a certified copy of the search warrant to enter the defendant's home. This was actually attached as an exhibit to the previous transcript. Again, we'd just like to admit this for the purposes of perfecting the record. It's a certified copy.
Okay?
I'll object. It's attached as court's exhibit number 2, pages 57, 58,
All right.
9. It's already, the court admitted that as an exhibit earlier today.
Oh, the transcript was admitted, Your Honor, but we'd like to admit the certified.
Okay. All right. Certified copy. States 2 for purpose of the motion?
Yes.
Okay. All right.
As Mr. Steele stated, the other was D10.
Yeah, I've got, that's admitted already.
Is that
So,
certified, Mr. Steele? No.
but it was admitted in the hearing on the 17th of November.
May we also tender this as a certified copy of that search warrant, though? As states 3.
All right. Any objection? Or same objection, sir?
Yes, sir.
Okay. All right. States 3 is admitted for purposes of the motion.
Thank you, Your Honor.
No, I'm good. I'm good. Anything else? Anything else in terms of the states and states 1, 2, or 3 for purpose of motion?
Well, Your Honor, we would ask to have a hearing to have the opportunity to show that lawful entry to the house and the search warrant for the phone, but we weren't sure if the court was going to allow us to do that. But if we are, we're ready to do that. We'd like to do that.
I'm not inclined to have a hearing on this, okay? Because, and here's why. Judge Newkirk's ruling fairly contains some principles of criminal procedure. And even though you've admitted these particular items for purposes of the record, which would supplant Baez and some, and would make the issue of your, that's one argument you could make in terms of the sufficiency of the arrest warrant and the search warrant. The issue still becomes is that that issue was decided by Judge Newkirk earlier, and you all from the state have not given me any. You're still not getting over 17-5-30. There still would be no reason for you not to have returned his property. There's nothing in law that would indicate to the court that you had the right to, to maintain and continue to investigate on those particular items that were taken. But so that's why I don't need to have a hearing necessarily on it, on that particular issue. So with that,
Your Honor, with the court permit, the state, we would like to proffer what the evidence would show, where we permitted to introduce the witnesses that we have. As the court,
I'm okay with that. I'm okay with you all. But I mean, the warrants would supplant the certified copies of the warrants that you have at this point in time would supplant Mr. Steele's argument. But the problem that you're going to have is that 17-5-30 would have required you to still return that particular property. There's no case law which indicates that particular issue, and the statute is pretty clear. It says, motion, if the motion is granted, because Judge Newkirk granted that motion, and it shall not be admissible against evidence of movement in any trial. So basically, you're getting a second bite at the apple. And in that particular circumstance, that's why the legislature makes some very specific issues about 17-5-25, which is execution of warrants, 17-5-30, which is motions to suppress, and then 17-5-54, which is different. That's trial disposition of property. So in that respect, that's why in this particular circumstance, you all still, now if you've got another argument as to why you didn't, other than why you didn't return his property, but you would have still needed to return it. You didn't go forward with that prosecution. If you've got some other case law you want me to look at, but it's pretty clear the reason that the legislature did enact this statute is because they didn't want the state. Yeah, and Mr. Steele's argument is, and just hear me out, you didn't have a valid arrest warrant to begin with. Now you got one, but you didn't have one when you had one in front of Judge Newkirk. You sought a search warrant, so you weren't in the right place and space to begin with, because you went in the house, somebody saw some marijuana, or somebody saw whatever it is, and they, in D10, they got they drew an affidavit, and they said, okay, we want to search the house. Well, you got to be in the right place and space to begin with to have the authority to search the house to begin with. Mr. Steele and his motions asked for suppression of anything that was taken in the house. So marijuana and anything else that was the basis of that. So that's fruit of the poisonous tree. He's argued that all throughout his motion. He's argued that. And so Judge Newkirk, by implication, had to consider it as part of his ruling. So you asking me to kind of, okay, well, the marijuana's over here, that's fine. but he didn't suppress the other stuff. We can still use it. That's not the way I interpret this particular scenario and interpret the law related to search and seizure of this particular item.
Your Honor, thank you. And respectfully, the issue of whether or not the state had a valid arrest warrant is actually proven with respect to, did we have one with the certified document that the court has that the state has tendered as evidence. So it's not a matter that the state did not have lawful authority to enter into the home.
But you didn't have it at the time that Mr. Steele.
We had the search warrant. That search warrant, that certified document that is in evidence, Your Honor, has a date on it. It was signed and filed well before Mr. Steele made that motion, and it was a part of the record of the clerk of court.
But you all didn't.
It was sworn out again.
The challenge is you all didn't take that up on appeal or anything. It was ruled upon by Judge Newkirk.
Your Honor.
So at this point in time, is it fair to Mr. Williams for you to have another bite at the apple? I mean, at this point, because you're asking me to go ahead and let you use this particular evidence that arguably another one of my judicial colleagues has said, hey, despite the fact that we disagree about how the motion has been styled, clearly it would be subject to being suppressed.
And Your Honor.
And even if I agree with you, okay, let's say you corrected all that. 17,530 is still fatal to you. You still would have needed to return the property, and you haven't given me any legal justification for you to keep that property and continue to then investigate that property or search that property. Unlike trial evidence that clear you could have done that. 17,530 is distinguishable because it's like the legislature seemed to indicate, well, we don't want the state to go ahead and continue to keep investigating an individual based on evidence that a court has suppressed. So that's kind of where I am.
Your Honor, if I may, the distinction is that there was a good faith basis for obtaining the search warrant and for getting the search warrant. A search warrant affidavit for the home itself was sworn out. There was, in fact, an arrest warrant that did exist. It was lawful. The fact that there was not one presented in the 16 SC case is what, yes, caused Judge Newkirk to suppress the evidence as to that case, Your Honor.
Okay, and why didn't you return the other stuff to Mr. Williams? You wouldn't have had to return the contraband. Everybody's clear about that. Contraband or weapons would not have been returnable to Mr. Williams. Why didn't you return the other stuff?
We had actually sought the search warrant, Your Honor, and I think that the court can look at the dates on the search warrant, on the arrest warrants, and see that we had actually already received lawful authority to search. We had already sought and obtained a search warrant for the items. We had already obtained what the state believed was lawful authority.
If Judge Newkirk has already suppressed the marijuana under the same analysis, okay, then why wouldn't the rest of the stuff that you took be suppressible at that point in time and fruit of the poisonous tree?
Your Honor, the ruling by Judge Newkirk came after the state sought permission to search the items. So we had what we believed to be lawful authority to search the items, the search warrants that were obtained, and we have witnesses that will testify.
Assume I believe you, okay? Assume I believe you.
Yes, Your Honor.
All right. Still, Judge Newkirk grants the motion to suppress. The case is over. You can't proceed on the 16 SC case anymore. The evidence that you all took, why didn't you return it?
Because, Your Honor, at that point, we have from sources,
that's the third time he's asked her that.
To believe that within items located within Mr. Williams' home, and this is separate and apart from the fact that he possessed marijuana. But at this point, we have information independent of that to believe that within his home, we would find evidence of these other crimes that we were
It's
at
double
that point
talk.
investigating. Prior
It's
to
double talk.
Judge Newkirk hearing the motions, prior to Judge Newkirk issuing the order that he issued, even if the court were to see it as more expansive than the state believes that it is,
She misinterpreted the law.
probable cause based on information and sources.
She's freestyling.
Independent of the fact that the defendant had.
She's freestyling out of her
marijuana
ass.
Or firearms or whatever it was that was seen when the officers initially entered the home to execute what was and what is. It doesn't change the fact that the arrest warrant that was in existence at the time actually was valid and gave them lawful authority to enter the home does not.
Judge Newkirk ruled that you didn't have that at that point in time, because at the hearing that you had in front of him, or Mr. Bailey represented you all on the 3rd of April of 2017, that was, you didn't have that particular certified copy of the arrest warrant. And so Mr. Steele by argument says, hey, look, I'm extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't that, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So if you look at that, even if I accept, which I have, I've admitted, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April.
Wow, do you hear this interpretation of the law?
That's exactly what he was doing. Okay, so you're asking me at this point in time to say, hey, Judge, we can correct that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, the return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that is now corrected, the problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. So you would have had to return that. You still would have to return the property to him. So because at this point in time, he's entitled, or he would have been entitled, he's asked, and Mr. Steele has already introduced from in the last hearing on the 17th, he's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, hey, I want the evidence back.
Your Honor, but the court did not rule that the state had to return that evidence, number one. There was no ruling as to that.
I disagree. I disagree with you. I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, can I do that? I mean, and even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. The property that, and then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree, because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.
Thank you, Your Honor.
All right.
You see that? Oh my God. Thank you, Your Honor. That's it. That's the way she ends her argument. Wow. Thank
All right, let me finish what I was going to say, okay? For purposes of Mr. Steele, you can prepare an order, okay? Sufficient to recap what the court has indicated during this particular motion. Now, I know that puts us in a position where some stuff that you may have, the state was going to admit or utilize. Does that change your position, ladies and sir, about where you are with what would be admissible in this particular prosecution?
Your Honor, there are items that, of course, are affected by the courts suppressing the evidence that was seized back in 2015. There are some items that we believe may have more evidentiary value than others. And so it does affect the evidence that the state intended to introduce in this case.
Well, I was just asking because if you need to sit and talk with Mr. Steele about what you can agree that would be not admissible at this point in time, given my ruling.
This is a bombshell, ladies and gentlemen. How y'all doing out there, ladies and gentlemen? My name is Purpose Time Podcast. Let me know how I sound out there with the audio, man. I've been going in and out. This is a bombshell, ladies and gentlemen. What we have here is that another court and another judge suppressed evidence from 2015. If you listen to academics, if you listen to Fresh and Fit, if you listen to anyone, one of the most damning evidence is the arrest in 2015. If you go back to the video I just showed you of Young Thug saying that you were in a car with Jeffrey and this arrest took place, and now they gathered the phone, and when they talk about you guys didn't finish this yet, you didn't do this yet, that's where a lot of this is coming from, right? The audio was off, but the Perfect Timing Podcast is not off. I'm sure audio will be back. You guys have heard many times about Young Thug on the phone about a wiretap. The Fresh and Fit Fed dude talked about a wiretap. The most damning evidence that they have is Young Thug on the phone issuing hits. If you don't have Young Thug's phone, then you no longer have Young Thug as this racketeering boss. And why did Gunna jump ship? How do I sound, you guys? How do I sound in the headphones? Do I sound good, man? You gotta tell me how I sound, man. Yeah, man, I'm sounding cool, man. So the audio is off with the courtroom, but the audio is not off with the Perfect Timing Podcast Television Network. Thank you to everybody watching. Make sure you hit the like, share, and subscribe. You want to watch all of the reactions. You want to watch all the shorts. The podcast channel was blowing up. Thank you to all of my new subscribers. Thank you, everybody, supporting the channel, holding me down on all of the networks, on Twitter, on Facebook, on Instagram, on TikTok, Howie Rick Rock. Thank you, everybody. Thank you, Dark Green. The audio sounding good. Audio sounding mean. Thank you. Shout out to the Bay Area, man. Shout out to my cousin, the Mac Toaster, Testarossa. Shout out to the KIU podcast, man. Keep it. You know what I'm saying? Shout out to rest in peace to my big cousin, Big Drama, man. San Francisco affiliates in the building. Real Lakeview stand up in the building, man. Hey, I like the podcast. You wasn't there, man. You know what I'm saying? I really like that a lot, man. Much success to you, young brother, man. Just much success, man. Really shining out here. I think we need more voices from the Bay Area, man. More perspectives, man. And I like how everybody got their own niche. Everybody doing their own thing. You know what I'm saying? There's room for everybody. There's billions of people who watch YouTube. So it's space for everybody to live and grow and prosper. So, you know what I'm saying? We don't do that crab in the barrel shit over there. I wish much success to everybody, all the content creators. Sir Ism was just in the building. Shout out to Sir Ism, man. Y'all make sure y'all tap in and subscribe to Sir Ism, man. Truth as I Know It stopped by. Another great content creator, introspective. The sister Toya the tutor, Toya the Texan, Toya the baddie, Miss Hattie. She was also in the building. Shout out to Toya. Other content creators doing their thing out here. Great perspectives. Make sure y'all tap into them. We support each other. You know what I'm saying? Like for like, share for share, sub for sub, support for support. Shout out to the whole community. 5.0, 5.0. I thank you all for y'all support. You know, today I feel very invigorated. You know, I was very passionate about the live today because of what's being discussed. If I've said earlier, the inspiration for this live came from the comment section of a DJ Academics video. Okay, hopefully the audio is coming back. In that comment section of that DJ Academics video, I pushed back on DJ Academics. Here we go. We're back. We're back.
Records were obtained through an order from Superior Court at the request of the former district attorney. They contended that the seizure of their records without probable cause was a violation of their Fourth Amendment rights and that the records should have been suppressed. The court in Kessler found that like bank records, telephone, toll, and building records are not owned or possessed by the defendant, but are business records belonging to the telephone company. The court further stated that the cases cited by the defendant, United States versus Baxter, Katz versus the United States, recognize the right.
Y'all see what's happening here?
Right of privacy in the toll and billing records of the telephone company. The court went on to say that neither defendant
is fruit of the same tree.
Nor
it's bad
the other
fruit. You
defendant
can't have it. It's bad fruit.
Had standing to object to the production of these records by the telephone company. Further, Your Honor, Regis, R-E-G-I-S-T-E.
One more time, R-E-G what?
I-S-T-E.
Okay.
Versus the state. And that is 292, Georgia 154. It's a 2012 case that is directly on point with what we have at hand. As an initial matter, telephone billing records are business records owned by the telephone company, not the defendant. As a result, defendants generally lack standing to challenge the release of such records under the Fourth Amendment because they do not have a reasonable expectation of privacy in records belonging to someone else. And that's a pen site of 249 Georgia 462 at 469. Accordingly, the court held that the appellant was not entitled to challenge the release of phone records in this case on Fourth Amendment grounds. Your Honor, the issue of standing has to be addressed before the court begins to even look at any substantive matters in this case. And given that the defendant has no reasonable expectation of privacy in the cell phone records of the Hertz Corporation, he has no grounds, no standing. He has nothing that permits him to come in and argue that the court should somehow find that the state's method of obtaining those documents was somehow improper. Additionally, Your Honor, the documents were turned over to the state by the Hertz Corporation. If the Hertz Corporation wanted to contest the release of its own documents, the Hertz Corporation and only the Hertz Corporation, and all that they released, I will also make clear, it's not at all anything comparable to information contained in cell site location data that a person has within a cell phone that is keep on their person and that moves around with them. These documents are simply documents that show that the defendant rented from Hertz a particular vehicle at a particular time and returned said vehicle at a particular time. There's no location information data to which the defendant could in any reasonable way have a reasonable expectation of privacy. Additionally, Your Honor, again, the records do not belong to him. He has no standing, no expectation of privacy in them, and he is not properly before the court contesting or moving that the court suppress the release of Hertz's own records to the state. So again, as well, Your Honor, the law on standing requires that the defendant show that he has standing, and his claiming that, just baldly claiming that the information sought somehow references or, as he put it, it touched upon the defendant or information concerning the defendant, still does not give him any standing to argue or ask that the court suppress information lawfully turned over that he has no expectation of privacy in, even if it was unlawfully turned over. He cannot argue that the court should suppress these documents. He does not have standing to move the court to suppress the documents. There is no infraction of any law or code of conduct. There is no incursion on any protected rights held by the defendant. That he is.
Yeah, it looks like from Kessler that he has a reasonable expectation of privacy in a conversation. He doesn't have the reasonable expectation of privacy in records. So is that kind of sum and substance what your argument is now?
Yes, as an initial matter, yes. And I mean, I ask the court rule on his lack of standing before we do anything else related.
Yes, ma'am.
Thank you, Judge.
Okay. All right, Mr. Steele, what say you about standing? It looks like that these are the Hertz records, correct?
Yeah, they're included, that's true.
Okay, is that what you are, as an initial matter, I would agree with Ms. Lovely, your client does have to have standing. I would agree. I would also tell you that conversations are different than records. So tell me why you think that he has standing to contest these records.
Okay. Well, and when the Honorable Court started to get into this motion, the court actually asked about Mr. Williams' motion to dismiss the indictment and or a motion to suppress evidence and derivative evidence based upon prosecutorial misconduct and abuse of grand jury powers. That was filed on November 3rd, 2022. I supplemented that, Your Honor, on November 10th, 2022. It's the same title, but I wrote supplement to Mr. Williams' motion to dismiss the indictment and or a motion to suppress. It also goes hand in hand, if you don't mind ruling at one time, I believe it goes hand in hand with the Mr. Williams' motion to suppress number 3.
Well, I need to deal with the issue of phone records. That's what you asked me to do.
The Hertz records,
The Hertz records. So let's deal with the Hertz records first. There may be other issues as to the indictment and some other things. But let's deal with that first. Client's got to have standing in order to address that particular issue.
So I raised it twofold. I raised the motion to dismiss the indictment based upon prosecutorial misconduct. Records of another company, although we want to assert standing, Maddox and the DDOS versus state says that there is no standing in those records. So I will, under the current case law, I'm not waiving the issue, but I'm telling the court, like I'm obligated to do, of the case law, and Maddox is.
So you would agree the state's proposition is correct?
I would agree that.
But you disagree because you represent Mr. Williams. Have I correctly, summarized that, sir?
Well, it's not like because I represent Mr. I think the law is inaccurate, but the way I understand the law today, we have to follow MADDOX versus state 346 Georgia Appeal 674 2018. It's exactly correct what Ms. Love said, that there's no standing in records of a corporation when you rent a car. But that really wasn't my issue. That's why I supplemented it. And that's why I did the separate motion to dismiss the indictment. And
Judge,
the reason,
if I may, and I do apologize to Mr. Steele, but I hear him going into the substance of a thing that necessarily relies upon his right to complain about the state's method of obtaining the records from Hertz. So I would ask that.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to that, as to the Hertz records.
understood.
Okay, so is there any other basis that you are asking for at this point in time?
Yes.
Okay, all right, what's that?
Okay. So, and the reason I want to call Mr. Sprinkle, if you allow me to briefly proffer. I just
Okay,
want-
you're going to proffer as to why you need to call Mr. Sprinkle.
Yes, because I think that's where it starts. So what happened is, Your Honor, is Mr. Williams is wrongly targeted by law enforcement for 10 years, since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkle and prove to this honorable court is as follows. First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home in July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office have to keep that property and then to send it to Cellbrite without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the District Attorney's Office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and Cellbrite, I would introduce through Mr. Sprinkle, says, as a courtesy of the District Attorney's Office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case. And it's not only Hertz. It is every grand jury subpoena. I've attached them to the motion. And what the grand jury subpoena shows is that from his office, presumably Mr. Sprinkle is on every one of these, he has a district attorney seal on the subpoena. The law requires the clerk to seal a grand jury subpoena. Mr. Sprinkle sends all of these subpoenas outside the state of Georgia. There's no authority for
That Mr.
a
Steele indicate which subpoenas he is referring to when he says all are, because the only one that I'm aware of that he has referenced is the Hertz subpoena to Florida. But as a matter of fact, I would just let him continue, and I will not.
Yeah, he's proper innocent.
Oh, he is actually.
Why?
He is.
Perfect time to did it again. This is what I said from the whole time. Prosecutorial misconduct, a rogue district attorney. Now, keep in mind, I said this is black on black crime. She is arguing that he has no rights. This is a black woman. Black district attorney is arguing that this black man who is a millionaire and a young father, keep in mind, those children's mother just got murdered. He was at home consoling those children's mother who was just murdered. She's saying that he has no rights. Prosecutorial misconduct is what I said from the beginning when she didn't charge Jack Harlow. And she said, I didn't want to get too sexy. This is about the mental health issues within the black community. Going back to the Takeoff case, going back to R. Kelly, going back to Bill Cosby, it's exposing a lot here. And this is what happens when you have all blacks in power. The police officers are black. The judge is the black male judge. The district attorney is black. Everyone's black. Stacey Abrams running to be black governor. And what has been done with the power? This is a black city in Atlanta who created Jeffrey. No one wants to take responsibility. And these are all black people. Do y'all hear this shit that I'm trying to put forth? I said this in my first videos on this topic. This is a black city. Black principal. Black teachers. Jeffrey had black his whole life. The black people in Atlanta created Jeffrey, who's a millionaire artist and a record producer, record company owner, and now they want to say that he is garbage because they can't control the cartels in Atlanta, in Chicago, in LA, in Southern California, where there's 1,500 illegal marijuana grows, and the cartel is threatening congressmen. The problem in Atlanta is not YSL, which is a successful record label. Pusha P was one of the #1 songs. The problem with Atlanta is the cartels. The problem in Southern California is the cartels. The problem in Chicago, how the guns and the drugs get there, is the cartels. We back!
Ms. Love's argument is, and the court's inquiry of you is, what reasonable expectation of privacy do you have, or standing do you have in these records?
This is not the issue. This issue goes to dismissal of indictment for prosecutorial misconduct. Mr. Williams was indicted. I'm not trying to suppress the evidence based upon your ruling and the case law. What happens now is there was such egregious misconduct by the district attorney's office.
So you're saying you'd like to examine Mr. Sprinkle for his motives, or as to why he sought these particular documents in this prosecution.
I want to subpoena, well, I have subpoenaed. I want to call Deputy District Attorney Mr. Sprinkle, because I want to ask him why he believes he had any right, which I'm contending violates Mr. Williams' rights to due process as stated in State versus Lampel, LAMPL, 296 Georgia, 829. It's in Division 2, 2015 case. It's in my motion entitled Mr. Williams' motion to dismiss indictment and or motion to suppress evidence filed on 11/3/2022. And what the Supreme Court of Georgia held was it is an extreme remedy to dismiss an indictment or a count thereof. However, it is a remedy. It's a due process violation. When the state's talking about standing, you can't have more standing than all of these people here who are indicted, wrongly indicted based upon the misconduct of the district attorney's office. And we don't have to sit here and allow the district attorney's office to violate the law and just put us in an indictment without this honorable court hearing it. And if this honorable court finds that it reaches the level of outrageous prosecutorial misconduct by the systematic abuse of process by our district attorney's office, then the indictment is dismissed. The state is arguing something that has nothing to do with this motion. This motion is not a motion to suppress. It is a motion based upon a violation of due process rights because everyone here, I assume, joined the motion. Everyone here is suffering from the state of Georgia's unlawful abuse of their power.
What's
That's the
Lample's
issue.
site again?
Mr. Lample's site is (296) Georgia, 892, Division 2, 770 Southeast 2D, 629, 2015. I had the honor of representing Mr. Lample. On that case, it went to Court of Appeals of Georgia, then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of Amara. Mr. Lample's the mayor of Amara.
Okay.
And that's why I would like to call Mr. Sprinkle, because he's sending out, under the auspices of a grand jury subpoena, with the district attorney seal, without the clerk seal, outside our state. They've taken evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider, and Mr. Sprinkle would be asked, there's a recording in a grand jury, and it happens on June 15, 2018. Mr. Sprinkle and law enforcement officers who were present in this courtroom subpoenaed a woman named Ms. Morton, M-O-R-T-O-N. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkle is said on recording right at the beginning. It's at 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkle tells the grand jury is this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkle what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which we already ruled. Why did that happen? Why did the subpoenas come without a clerk? Third one is why would the subpoenas go outside of the state of Georgia? The fourth one is why wouldn't you return the property? And the fifth one is why would you bring a human being before a grand jury when you don't have a real bill of indictment and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man.
Okay.
Your Honor, the defendant still has not addressed the issue of standing as any of the.
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been aggrieved. He has to have an expectation as it relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test. And he's also saying, hey, he's an aggrieved person because he's under indictment for these different charges. So,
and Your Honor, if I may, I don't know why Mr. Steele cited Lample in his brief because it actually supports the state's position in this case. In Lample, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy in. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the court's
So one thing I want to point out, the audio went out again in Atlanta. Thank you for pointing that out to the new person watching. Thank you for everybody who watching. It looks like the video went out. The audio should be coming back quickly. One thing I want to point out is they quickly changed attorneys. The state quickly moved.
Court.
We back, everybody.
They've been indicted, and when the Georgia Supreme Court says, nope, you lack standing, their being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so he has bundled up a whole bunch of matters as they relate to.
She keeps saying that based on what?
Frankly,
I want the judge to make her provide the case law that says that he doesn't have a right. Because the last time I checked, the burden is on the state.
They could literally email them to us, as some of them will do. But the only entity and the only people that have a right to complain about that, and right now he's skipping over the fact that he has no right. He's asking you to jump right to, let's just get into the substance of an argument. And that is not the way that the law works. Mr. Steele is well aware of that. He is a very seasoned attorney. And he is attempting to escape that fact by just pushing forward and conflating all the arguments and making sure that they collapse into one mud pie. But Your Honor, I believe, and I'd ask that the court address that threshold matter before we get into anything else. And specifically, before we begin bringing assistant district attorneys in to talk about what could constitute work product and to discuss matters that have nothing to do, that are in no way matters that the defendant has a right to complain about.
I'd like to speak a second, please.
She got to prove that. I want to see case law. She got to prove that. Where does it say that he doesn't have a right? Just because you're saying it, they brought her in because she argued better than the other. That's all she's doing, is simply arguing. She's freestyling. Not once have they presented case law. They have not successfully argued anything this morning. She is simply freestyling. They are in a free fall. Now, if you go back to the video I showed earlier of Young Gunna testifying yesterday, they specifically had Young Gunna speak to this arrest. They are trying to legitimize the arrest and what they've done. That's why they let Gunna out after 7 months, and that's why they kept him in. They have committed slavery, prosecutorial misconduct. They should have given both of these individuals bail. I argue that if they would have been giving them bail, let me stop saying given, they have a right to bail. And if they would have not subverted, you said subverted, but if you wouldn't have subverted Jeffrey and Kitchen's rights, they would have gotten bail. They would have been able to make music and put on a better defense. Even now you're getting your ass whooped. So imagine if they were free, able to make music and fight you in the media. And put in the media all of the nefarious thing that you've done. Now think about what the judge said. They did not have the warrant properly dated on the day that they did the search. And the judge said, what if I give you the fact that you want to go back in time and fix the date today? Even if I give you that, you still had to return the evidence. Now think about that. They want them. Think about that. They want the ability to go back in time and change the date to legitimize the warrant. I didn't even know that was legal. The judge said that he would allow that based on the fact that it's RICO and he's some type of heinous criminal, that he would allow them to backdate the warrant. Can y'all believe that? But he said, even if I allow you to backdate the warrant, you would still have to have returned the property, and you were not allowed to probe the phone, and anything you got out of the phone would not be admissible. Why? And he had asked her 10 times on record, this shit gonna be reviewed tomorrow by analysts, judges everywhere, how embarrassing these black women, the black DA, the black judges, all black people is fucking embarrassing, y'all. It's fucking embarrassing. 10 times he said to her, you still should have returned the property. That's why that's why the lawyer's gonna win on prosecutorial misconduct, because there's a lack of understanding of what is legal and what is right. You are the district attorney and the state. How come you are not able to express the wrongness and the legal right of this gentleman to have his property back? I had to ask you 10 times. I had to ask you 10 times, as if you don't understand that you broke the law and it was improper that you not return his property and you not probe the phone. You are still arguing as if you had a right to do so. That is the basis for prosecutorial misconduct. He had to redirect her 10 times. He said, you still don't get around the fact that you should have returned the phone. Why didn't you return the phone? Why didn't you return the phone? And not only why didn't you return the phone, but you knew that you should have returned the phone. So why did you then probe the phone for records and then use that records to create the indictment, which is now why we're here, and he's challenging all the indictment and wants the indictment thrown out because of the way you went about gathering all of your evidence. He's giving me 5 bullet points. Again, on the what you, and the burden, and ladies and gentlemen who's listening, the burden is on the state. See, that gets lost when it's a black man in court. Jeffrey is innocent. He's incarcerated. You have DJ Academics making all these fucking jokes. Oh, he's going to jail. I think he's going to get 20 years. Fuck DJ Academics. Fuck DJ Academics. You ain't no fucking lawyer, you fat piece of shit. You racist. Talking about black culture is crime culture. He had no idea what the fuck he was talking about. DJ Academics saying all that bullshit, but he didn't know shit about the suppression. Perfect Timing had to jump in the comments and say, hey, Academics, I got some pushback. What about the warrant? Do you have any? I said to Fresh and Fit Fed, do you know about the ruling on the warrant? So now, today, with Young Thug in court, everything that's being talked about is what Perfect Timing brought to light. If you go to Academics video, if you look at my comment, everything that's happening today is not based on Academics, stupid ass. It's not based on Fair, Fresh, and Fit. It's based on Perfect Timing Podcast. I said to Academics, I said to Fresh and Fit Fed, very politely in the comments, I said, brothers, I got some pushback for you. I said, do you know about the ruling on the wire? And I said to Fed, I said, you in this video mentioned how difficult it is and how damning the wire evidence is. What do you say now, Fresh and Fit Fed? The evidence is suppressed. The cell phone has been suppressed. All of the information from the cell phone, that white lawyer is going to get in the back room with that DA and whoop their ass and rip up this case and take apart everything. No, you can't use that. No, you can't use that. No, you can't use that. There will be no case left after they sit down in the back room and go through the evidence of what will be admissible and what you obtain via this unlawful search. Perfect Timing, you going in. Come on, audio. Come on with the audio. The judge ain't even in the courtroom. Okay. Judge ain't even in the courtroom. It look like she talking to somebody though. Look like she talking to somebody though. I got another video I want to show of young Gunna with the Crime Stoppers. Now, how do you guys feel now about what took place with young Gunna yesterday, taking into account the prosecutorial misconduct? And think about what I said at the beginning of this podcast and what Mo Grant, the lawyer, told academics. He said the prosecutors have acted poorly. There is a case for prosecutorial misconduct. See, this is the thing where black people think that no one is looking. That's why they fucking up the audio and the Zoom. The black woman doesn't want other lawyers and judges to see what they're doing to these young black men. Other lawyers are on YouTube. You got the what's the guy name? The lead attorney. They're gonna break down this, and he's in Atlanta, so he may be biased, but I'm not biased. They're gonna break this shit down. And it looks very bad on black people and black legal professionals, the way they're treating these young black men. Especially, see, academics and Charlemagne and all these people have said it's okay, because I've argued from the beginning that there's been prosecutorial misconduct. Everyone has said it's okay because Atlanta was violent. Everyone has been ignoring this DA and what the DA has done to get this arrest and this RICO. I believe the feds didn't ignore it because that's why the feds didn't come in. But all the black liberal Democrats who wanted you to vote for Stacey Abrams have ignored this district attorney's conduct. And she has been rogue. Just like the judge in the Meek Mill case. I wonder what happened to that judge in that Meek Mill case. Kept Meek Mill under slavery for 19 years. I wonder if she's still a judge. Still putting black men in shackles. What's up with y'all audio, man, Atlanta? That's all right. The audio gonna be fixed soon. It's gonna be back soon. You know they gonna get the audio all day today. They've been playing with us with the audio. My boy back up there arguing. I want to hear what he got to say too, Mike. Okay. Whenever the black screen go, we're gonna get back. We're gonna be getting the audio.
Mr. Bailey's, not Mr. Bailey, but Mr. Sprinkle, you're challenging by way of the evidence that you were presenting, or that I said you didn't have any standing to see what Mr. Sprinkle in fact did present to that grand jury and what he told them. So
I actually won't do that. What I'd like to do is, why did Mr. Sprinkle serve grand jury subpoenas? Why did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
Is it discovery?
Yes. Okay. Will not ask anything about what occurred in grand jury, except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion to suppress? Yeah, that's what the motion was. Okay, I ruled upon the issue of the all right, I think I'm back on at this point in time. In terms of motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2. The court is of the opinion that.
Whoa! News bulletin suppressing the subpoenas. Oh, prosecutor, this is getting dismissed.
Of the relevancy of the records, but also they are protected by work product under 24-5-501. And for those reasons, I'm going to deny. I'm going to grant the state's motion to quash on those two subpoenas. All right. Anything else?
Thank you, Your Honor.
All right. I have some proffers I need to deal with. Let's see, Mr. Where is he? Mr. Hoover?
I'm sorry, Your Honor, before we do that, I just want to bring the court's attention. Mr. Kendrick has both expressed statements on the record. We have a witness here, spoken to counsel. He doesn't intend to go forward on that motion.
He does not intend?
We were hoping we could release our witness who's in here.
Yes, any objection, counsels?
No, just to be clear, we're not withdrawing the motion. We would just like to argue that on another time.
And your name again, I'm sorry.
Doug Weinstein, W-E-I-N-S-T-C-I-N.
Mr. Weinstein, what's your client's name again?
Giovanni Kendrick.
I'm sorry, I don't know, we're just hoping our witness might be able to go.
Well, you know, folks, I'd like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say, and we're kind of a little bit behind. So we're a little bit behind in terms of just being able to properly conduct court. So what is your motion? Your motion is to suppress?
Yes, Your Honor.
Could you give me just a few minutes and I can maybe have that motion heard since your witness is here?
No, Your Honor, but if he doesn't want her today, we don't object to a continuance. So
Oh, okay, all right, so your motion is suppressed, all right, okay, all right, I understand,
Thank you, Your Honor.
I'm with you, okay, yes.
Your Honor.
You give a mouse a cookie, what is it you want, Mr. Stark?
Thank you, Your Honor. I just wanted to make sure that I respect the record. I know that you have not ruled on the
It's not your turn yet.
Well,
You jumping in front of Mr. Steele now?
no, I am not jumping
Okay,
in front of
okay, all right, what is it you'd like to tell me?
Well, I filed the exact same motion that Mr. Steele filed
And
regarding
your client is, sir,
Stillwell.
Mr. Stillwell,
And that
okay.
was filed on November 16th. And
The motion to dismiss the indictment
motion to dismiss the indictment.
and motion to suppress evidence, you wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing but rather the prosecutorial misconduct, which I believe as citizens of the United States, we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by illegally issued subpoenas.
I'm going to deny the motion to dismiss the indictment. Okay?
Okay, well, I just wanted to make sure it was on the record that I too have filed that motion and I want to put that on the record.
All right, I'm with you. Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else?
Actually, Judge, just while we're here for the record,
Yes, Mr. Menezes.
I have to adopt the motion as ready, but I did want to refresh the record that that's on me, and that was effective, that he went forward and also adopt Mr. Steele and Mr. Sharp's motion.
All right. Well, you probably should reduce that to writing, but Ms. Rosen wants to review, will include that in order, please, madam.
Yes, Your Honor.
Yeah, I'm going to, in the motion to suppress and motion to quash, okay?
And Your Honor,
You can-
would you allow me to incorporate Mr. Steele's argument into the record on behalf of Mr. Steele as well, so I do not need to cite to the same cases and,
Yes,
thank you.
so we'll include you as well. Okay, anybody else? All right. Okay, before I was interrupted by Mr. Sharp, Mr. Hoover.
Yes, Your Honor.
Okay, do you have the issue of the proffer that you'd like to complete at this point in time? Do I have I was going to ask you to complete that issue of the proffer. And then also, if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proffer.
Ms. Rosenwald, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Someone after you were disqualified as to Mr. Blaylock, to see if Mr. Blaylock was on board with you continuing to represent Mr. Someone.
Well, Mr. Blaylock's attorney is here, so if the court wants to continue, we can at this point.
Where's Mr. Black's attorney?
This is me, Attorney Justin Hill, Your Honor.
Is it Justin Hill?
Yes.
Okay. And you are counsel for, I'm sorry, Mr. Hill, I apologize.
I'm sorry, you said one now?
You're counsel for whom, I'm sorry?
Mr. Blaylock.
Mr. Blaylock, okay, all right.
Demond Blaylock, yes.
All right, Mr. Rosenwald, do you have a copy of the proffer? Could you please, ma'am? I don't think I have it in the list here. Huh? Oh, yeah. We kind of jumped the gun a little bit, just to, so that myself and Ms. Weaver are in sync as to who is present today and who's representing whom. Could we just take roll call as to who's here? So we'll start out with my left, your right, gentlemen or ladies. If you're representing anybody, could you kind of state who you are representing, please? Okay, all right. All right. Okay. That was your
Adrian for the state, Your Honor,
Okay.
Deputy District Attorney.
Yes, ma'am.
John Floyd from the state.
Second District Attorney Simone Hilton for the state. Assistant District Attorney Lizzie Rosenwasser for the state.
Okay, all right, now for the defense counsels and their clients. All right, we'll start off, Madam, I forget, and on the right side.
Chelsea Golden from Mouse Farley.
Thank you, Madam.
Anastasio Smenez for Mr. Mouse
David Ross, Shannon Stewart. Max Shard for Shannon Stewart.
Pete Adams, Jeffrey Williams.
I'm Brian Steele, I'm also the representative.
Okay. All right, counsels in the back, anybody who's representing, anybody here today, Madam? In the orange? Yeah. I'm sorry, one more time? Yes, ma'am.
Gina Bernard for David Myrick.
Michael Russ for Mr. Greer as well. Grew up here, sweet shout out, I got Mr. Dorsey.
All right, continue to the center.
Doug Weinstein for Mr. Diamante Kendrick.
All right. Hold on, Mr. Harvey, I think it's you.
Oh, go ahead.
With Mr. Nelson, along with Nicole Westmoreland, she is on Zoom. You can see that she is on.
Yes, sir, thank you. All right,
Angela Williams for Mr. Ryan.
thank you, Madam.
Sean Hoover, Francis Sullivan.
Okay,
Justin Hill for Demond Blaylock.
all right. Continue, Madam.
Christy Gladden for Trontavia Stevens.
Thank you, Madam. All right, anybody else to my left, your right? Okay, all right. Just want to make sure who was here along with clients today. All right, okay. Thank you very much, Council.
I apologize. I'm here on the platform. Tiandra Callan on behalf of Mr. Khalif Adams.
Okay. All right, anybody else on our Zoom platform? I'm sorry that we had such difficulty with today. Anybody else? Is your client, Mr. Adams, on the platform as well?
He is not that I see, Your Honor.
Okay.
He's in the back row.
He's in the what?
He's in the back row.
He's here actually in court. He's in the gallery, Madam.
Thank you, Your Honor.
Okay, all right. One more time, Counsel, your name. I apologize now.
Tiandra Callan.
Well, and can you spell that for us, please?
Sure. First name is Tiandra, that's Teombre. Last name is Callan, Callland.
Okay. All right. All right. All right. So we're talking about profit. So Ms. Rosenwasser, do you have that?
Yes, Your Honor, I was able to locate a transcript from a previous hearing.
Okay, all right. So can we take care of Mr. Blaylock's proffer at this point in time?
Yes.
All right, let me go ahead. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? Investigator, would you solemnly swear or affirm the evidence you'll give in the matter now hearing should be the truth, whole truth, nothing but the truth, so help you God so affirm?
Yes, sir.
All right, you put your hand down. Sir, we're just gonna ask you a series of questions just related to proffer, nothing else. And then after that's done, I'll make a decision as to you and your counsel, okay? All right, Ms. Rosenwasser, if you go ahead and read that particular cover, he's already been sworn, so.
Sir, I recognize you're currently being represented by, I'm sorry, your name, sir.
Justin Hill.
By Mr. Justin Hill, is that correct? And sir, were you previously represented by Mr. Sean Hoover? Are you aware that Mr. Hoover is still representing your co-defendant, Mr. Antonio Sumlin? Okay. Now, have you been advised of a potential conflict between this attorney still representing Mr. Sumlin? No one has advised you of a potential conflict? So, yes, someone has spoken to you? Okay. Is that your attorney right now who's spoken to you about that? Okay, who spoke with you about that? Okay, did a woman, Mr. Rivera, speak to you? guys ever come and talk to you about this case? Okay. Was it an attorney as far as you know? Okay. Did she explain to you that there's a potential conflict with agency? Okay. Are you aware of, so you are aware of that conflict? Okay. You understand, that you have had, even if you have had meetings with this council, Mr. Hoover, you still have no objection to him continuing to represent your co-defendant? Okay. And you met with someone else independently outside the presence of Mr. Hoover or your current counsel about a potential conflict of interest, is that correct? Okay. And you have stated that you waive any potential conflict and you wish for this gentleman to remain your counsel and you waive any conflict with your co-defendant being represented by Mr. Hoover. Okay. And has anyone promised you, threatened you with anything, coerced you, or in other ways forced you to consent to this? Okay. Do you waive any other potential issues, so including that anything that this counsel has learned from you could be used in your co-defendant's defense? You don't waive that? Try again. Do you understand that if you went to trial, anything that he learned when he was representing you, Mr. Hoover, could be used to help your co-defendant yourself? Okay. Do you still waive any conflict? Okay. Your Honor, I believe that confirms any conflict. Okay. Waive any conflict.
Mr. Whitlock, did you, before signing and have the opportunity to talk to counsel your satisfaction? Yes? Okay. And you give these, this is waiver freely and voluntarily, self-decision to waive any potential conflict in this case? Yes. All right. Do you have any other questions about this particular conflict you want to ask me? Okay, I won't go ahead and
This shit sound horrible.
I believe that covers all the waivers.
They should be embarrassed about this audio. Thank you. Fix the audio. They should be embarrassed about this audio. This a $1 billion corporation in Atlanta, the city of Atlanta, the state of Georgia. Do you understand how these work? When you're a governor, you're an executive, you're a CEO of a corporation. California has one of the 5th largest economies in the globe. The governor of California is basically a CEO of one of the largest global corporations and responsible to feed the entire world. 80% of the world's greens come from California. California is like a China, right? Because it trades with the globe, right? They should be embarrassed. I'm starving, y'all. I had to go get me something to eat. I didn't know what time it was. I haven't did a live stream like this and I don't know how long. I won't be doing live streams like this no more. This ain't even long. This ain't even long. When I had my show, my everyday show was a 4-hour show. My everyday show, when I had the perfect timing show, the Perfect Man show, it was a 4-hour show every day from 1 o'clock. I'm never doing that again. I'm never doing it unless they give me 100 million like Joe Rogan. I'm never doing that shit again. Motherfuckers didn't support. Motherfuckers didn't support at all. I put a lot of time and effort into that show. 4 hours a day. Brand new thumbnail every day. Brand new topic every day. Thanos Monday. Watch Taco Tuesday. All we do is win Wednesday, selfish Thursdays, free fries Friday, and I was preaching on Sunday. I was giving out so much content. It wasn't appreciated by the audience or YouTube. It really didn't feel good as an artist and a creative. And then the shorts come, and I can grow my channel with the shorts to just let you know that YouTube is a business, and I took my emotions out of it. So now you don't see me doing live streams, despite I might want to do a sermon. I want to do it. I might want to do a sermon. You know, I miss my mom. Rest in peace. Condolences. I might want to do a sermon, but it's like YouTube isn't going to reward my art. Okay, we might get the audio back. You know, whenever they go black, then we get the audio back.
Mr. Hoover, Mr. Fleet, what is your representation?
Your Honor, at one point he had an attorney. I'm not sure if that attorney was withdrawn. It was for Larry Hemingway. So I don't know if she is for Larry Hemingway. I don't know if she's withdrawn. I know he had an attorney when I was doing a lot of motion service last month.
It's, from my understanding, Ms. Hemingway still represents Mr. Fleetwood. I'll definitely double check.
I'm sorry, it's not, she works in the same office.
Yeah, I think that was the problem.
I'm not sure if she's formally withdrawn though yet, so that may be why this has arisen.
So, Ms. Bernard, can we do, just a housekeeping matter? Can you ask her to, formally, she's not done so, withdraw? And I will ask Mr. Hoover to go ahead and, continue that process of representation, okay?
Yes, sir.
Thank you, madam. All right, so Mr. Hoover, you'll take care of that and go through this?
Yes, Your Honor.
Okay, all right. Mr. Arnold.
Mayor.
Where are you, Mr. Arnold? Oh, good afternoon, sir. Who's your attorney?
Ashley Merchant.
Ashley Merchant, okay, okay, all right. All right, sir, we're gonna go ahead and, I believe that, she's had something else to do this afternoon, but we've been in touch with her, okay? So just, give me a second. All right, Mr. Beebe?
He's still in call, so.
Yeah, is he on the,
No, he's not on the platform.
who is his lawyer?
The Partridge has to go to Upson County for another trial today.
Okay, all right. All right, Mr. Eppinger. Mr. Eppinger, you ready to have it?
He's right here.
Oh, thank you, sir, I apologize. Okay, Mr. Eppinger, who you represented by, sir?
Eric Johnson.
Eric Johnson.
There was no communication.
Okay, all right, all right.
You know, I have my office reach out to Mr. Johnson, so we will make sure it will be.
Thank you, sir, appreciate it. All right, and Mr. McMullen. Mr. McMullen.
I believe.
Who? I'm sorry.
Amanda Young. I believe
She withdrew, and Attorney W.B. Green will be representing her moving forward. I want to say yes, but I have not double checked myself.
Who is Mr. McMullen's attorney now?
W.B. Green.
Do we have a withdrawal? Who is his prior counsel?
Amanda Young.
Amanda Young?
Yes.
Do we have a withdrawal from her?
Yes, the court. Yes, the court.
Okay, all right, do we have an entry with Mr. Green?
We do not.
I'll make sure it gets on your honor.
Four on that, looks like this is green area, here's on four on that. Okay, perfect. Okay, all right. Yeah. Mr. McMullen, I'm gonna go ahead and since your counsel's not here, we do have some, he'll talk with you, but I'm gonna release you at this point in time, okay? Mr. Evans, Mr. Evans, I'll release you at this point in time as well, since your lawyer is not, Mr. Johnson's not here as well. Mr. Beebe, where are you? Not here. He's not here. No, Mr. Beebe's not here, okay, that's fine, thank you. All right.
Some people is working on my house. They gonna knock out. No, I'm not gonna say nothing negative. Let's say, God, thank you for this podcast. Thank you for this microphone. Thank you for this opportunity. Thank you for our freedom. Everybody able to watch. Cause it's like, we take things for granted, God, and you blessed us with so much. I want to say thank you. Take this opportunity to say thank you for things that I don't even know I've been blessed with. It's impossible for me to know all the many gifts and blessings that's bestowed upon me, life, breath, liberty every day. But I do want to take this time out to repent my sins, ask for forgiveness from all of the wrongs that I've been done, ask for guidance for the error of my ways. I pray a blessing and the covering upon this platform, microphone, and all the audience members who came and watched and supported today. I want to pray for the individuals who are incarcerated behind bars, pray for individuals who have lost their life, pray for the individuals who are without family members like myself. Jeffrey's children are celebrating the first holiday season without their mother. Their mother was murdered in the bowling alley. I want to send prayers out, and people forget about that, but I want to send prayers out to Jeffrey's children. Yeah, man. They lost their mother. I lost my mother. It's difficult. I want to pray for them, pray a covering over them. I pray a covering over all of my children. I want you to know I love you and cherish you despite our relationship. God loves you. I ask all these blessings in your name. Amen. Yeah, just take an opportunity, man, to give thanks. I mean, we watching this trial, and some people don't have their freedom. It's that Lazo lost his mother. Like, we dealing with a lot of loss, man. It's my first Christmas without my mom. And Young Thug's children lost their mother and their father. They're teenagers. I've asked from the beginning, who's watching Young Thug's children right now? They just lost their mom. Their dad is incarcerated on a RICO charge that they know he's not guilty of. When they came to Young Thug's home, he was consoling these children who had just lost their mother at the bowling alley at a birthday party. Traumatic event, bro. After being quarantined, none of the kids did good during the quarantine. These are teenagers, fresh out of quarantine, lose their mother. And they didn't lose her to cancer. Their mother was murdered. I send my love and blessings out to you, Lazo. Condolences, and we got some angels looking over us, and I want to say thank God for the angels looking over us. And you know, it's been tough, bro. It's been tough, bro. It's been really tough. I thank God for my wife, and I thank my wife and my children for being there. But she lost her dad last year to COVID. He was young. She's young. So both of us lost a parent. And there's a lot of people who lost grandparents and parents to COVID. I don't know. We talked about the mental health of America, the American psyche post the pandemic. Because there's a lot to take in. You have long COVID, right? Where people are still feeling the effects. My wife had lost her hair. Her mother had lost her hair. You know, people may not be able to have children. The mental health effects. I remember someone saying while we're in the midst of the pandemic, a psychologist said, we will be dealing with this for the next 10, 15 years. And everybody got scared. And they didn't understand, like, what do you mean we're going to be dealing with this? And he was meaning the mental fallout, the mental health fallout from quarantining the children, the humans, the mental health fallout from long COVID, the mental health fallout from women who are unable to feel beautiful, to feel worth in this society where we make them value themselves based on their beauty. The long-term fallout from quarantine, from COVID, like, we're not discussing that. What's happening in our society with all the violence and the lack of relationships, the lack of love and respect for each other. We have fallout. It's not long COVID. We are going through something psychologically post-COVID, post-quarantine, post all the deaths, post all the births. Now, so on one side you have a lot of death, but then there was a lot of birth. You had the COVID baby boom, right? People who weren't together coming together, people quarantining together, people being forced to reconvene and couple. So you had a lot of death on one hand, right? People dealing with that tragedy, dealing with that loss, and then you had a lot of unexpected growth. That's painful. When you have unexpected growth, that can be pain. It's good, right? But it's also painful. Like, that's my analogy with QC and Death Row. Unexpected growth, unexpected exponential growth. I'm now a $1 billion CEO of a record company. I'm now a mother. I never intended on being a mother, but COVID hit. We were quarantined. I couldn't work. Now I'm a mother. COVID is over. And now I want to live my dream. But now I have a child. I have a marriage. There's a lot going on with the divorces, with the breakups. So I just think we got some mental health shit to deal with, bro. Telling you, we got some mental health shit to deal with, bro. America, black people specifically, I've pointed out some things people have been scared to discuss about this Young Thug case. I'm a small YouTuber, but if you listen to academics, he keeps using the N-word, and I don't like it. He said ninjas this and ninjas that, and he's talking about ninjas snitching. Up until now, the narrative put forth by the Atlanta DA has benefited Charlemagne and academics, and their idea that black culture is crime culture and that black people are unloyal and will snitch. Everything that academics promotes every day about blacks and black men is extremely negative. It has downstream effects in the judicial system. Today, academics were served a heaping helping of STFU. You don't know what you're talking about, bro. Sit down. Go back to doing music. Go back to doing Chicago, Chirac, and Little Dirk. Stay out of these black issues. Stay out of these black issues. Stay out of these ADOS, FBA, indigenous issues. You have no idea our struggle, our story, because you probably believe in slavery. My family was never slaves. We own the land in Mississippi that we used to farm. That means my family hasn't paid rent in over 100 years. That's real wealth. You have no idea about the Great Migration with and I was just in Oakland, and we were talking about the Great Migration because all of our mothers and grandmothers passed away, but our mothers and grandmothers migrated to Oakland and San Francisco. Like some of the people, like you talk shit about Chicago, but those are success stories because those were blacks who fled the South and went to Chicago or New York and San Francisco and LA, and they bought homes and they made lives for themselves where they never had been before. That's a success story. It's the same story that you tout, right? Right, academics? Right, Fresh and Fit? It's the same story that you tell. It's your fresh out of the boat story that you say your parents are so great, but you want to shit on Chicago. You want to shit on San Francisco and LA, but you don't know those are success stories for us. They were running away from death. They were running away from all these things in the South, and they left with nothing. Just like your parents left with nothing and came to America, they left with Mississippi. They left Alabama. They left Arkansas under distress with nothing. You know, Richard Pryor got a joke about Mudbone, and he said, I came up here from Tupelo, Mississippi. I drove here 3,077 miles on a tractor. See, I was working for Mr. Johnson, and Mr. Johnson, he liked them big women, you know, them fat women. He said, Richard, you go down there to the train station, and you pick that girl up from the train station. Now, I go down there to pick her up from the train station. I didn't know. She get off the train. She big as all outdoors. She good 400-500 pounds. I didn't say nothing about it. I can say, God, Lord, I don't know how she gonna get in the buggy. She get out the truck. She slapped me on the back of my head. Pick up them bags, ninja. I said, oh my God, this is a special one right here. I get the bags. I said, yes, mister. I get the bags. I put the bags in the cart, and she step on the cart, and she flip over, and she fall in the mud with her big foot. I bit my lip, trying not to laugh. I bit my blood trickling out my lip because I can't laugh. I know if I laugh, they're going to hang me. So I help her up. I say, you okay, missy? And she slapped me on the back of my head. Wow, boy, why you didn't hold the cart steady? And I didn't say nothing. I help her get in the cart. But I'm thinking to myself, as we riding back home, how I'm going to get this heifer now? So Richard Pryor tells a story. So he said, I know Master going to make them greens, right? And her big 500-pound hog-eating ass going to eat them greens, and she going to have to go to the bathroom. So I cut a hole in the outhouse, and when she go to the bathroom, you hear this big old splash. He said, I jumped in the tractor, and I drove up here. He said, I jumped in the tractor, and I drove up here. So that's just a joke. You know, Richard Pryor, the Great Migration, but an example of how he had to flee the South and go to Chicago, go to LA, go to San Francisco, and they were forced to flee the South and make lives for themselves. Our mothers and grandmothers and aunties became nurses and married military men. They bought multiple homes in San Francisco and handed down millions of dollars in wealth. This is true also in Chicago. What happened is the crackheads smoked up the millions of dollars in wealth. And that's how all of us are disenfranchised right now. But they amass wealth. The homes that our grandmothers purchased in Chicago and Harlem and the Bronx are now worth millions of dollars. Those homes in Harlem are worth $3 million. But they were circumvented from us via the crack era. But academics and Fed don't talk about this shit. But that's our immigrant story. I'm proud of my mother and my grandmother and all of the mothers and grandmothers and grandfathers who immigrated from the racist South and created Black wealth and families in all of the major cities, coastal cities in America. Let's show this video and because I was talking about, I'll be preaching damn near 4 hours. Why am I preaching? I can get up off of here. Let's go to Young Gunna working with Crime Stoppers, man. Young Gunna been working with the Atlanta DA. Young Gunna was primed to go and testify. Young Gunna been working with the Atlanta DA. Let's look at Young Gunna working with the Crime Stoppers and cooperating as a witness as a youth before we knew him as Gunna and YSL.
I mean, it's a murder case. No one wants to go down for it. No one.
Devontae Benton's younger cousin, Sergio Kitchens, says Benton is on trial for murder simply because his friends turned on him.
Just go to see, like, you ain't got no real friends out here. You know what I'm saying? I learned from that. You know what I'm saying? Like, I'm not happy that it happened, but you know what I'm saying? I'm kind of good to see that, be on the outside looking in.
Kitchens is now a member of the neighborhood rap group SPC, known as Shady Park Clique, like his cousin once was.
That's why it's come back to that street word, snitch. No one's want to be labeled as a snitch. I don't want to tell on him because somebody might try to come kill me or someone in my family.
Kitchens says Benton first lied to police because he didn't want to rat out another member, Clarence Carter.
Everybody, like, know, like the streets know, and so everybody looking at it like it was wrong because this man would let my family member, you know what I'm saying, go down for something he did.
Right. Kitchens claims Benton and Carter were both wearing red the night Jasmine Lynn was shot.
It was just a coincidence of how it was put out. Like, they actually had on the same exact color.
Okay.
He just had on the hood, and Devo didn't. He had on a regular shirt.
Kitchens.
It's the same argument. Are you hearing what Young Thug just said? He said, my cousin is going to jail for something that somebody else did. So all I'm doing is just letting the police know the person who did it, or letting them know that my cousin didn't do it. Young Gunna is using the same language today. I'm not telling on Young Thug. I'm just doing the same thing I did with Crime Stoppers and telling the state that I'm not a part of a gang. YSL is a gang. YSL as a gang needs to stop, but I'm not part of it. And the drugs that were in the car were not mine. The persons whose drugs they are needs to take responsibility for the drugs. That's what Gunna is saying. It's the same thing Gunna said when he worked with Crime Stoppers. Gunna went to the state and said, those drugs are not mine. And he probably told Young Thug, you better take your drugs or else I'm going to tell them that they're not mine. See, this is a new age of the street dude. This is what happens after it ain't tricking if you got it. When you dilute the game. This is what happens when you dilute the game. He was allowed to become a gangster street rapper after cooperating with the Atlanta DA and working with Crime Stoppers. Who is surprised that he has this? He had a leopard doesn't change his spots. Who is surprised that Young Gunna acted in the same way that he did several years ago? I'm not surprised. I'm not surprised at all.
No one wants to go down for it. No one.
Devontae Benton's younger cousin, Sergio Kitchens, says Benton is on trial for murder simply because his friends turned on him.
Just go to see, like, you ain't got no real friends out here. You know what I'm saying? I learned from that. You know what I'm saying? Like,
his friends didn't turn on him. Nobody spoke to the police. Nobody gave a statement. Are you guys listening? The narrative that they're painting to make Gunna look good is that his friends turned on him by not giving a statement. Do you understand the mathematics? You have to pay attention. That's why I'm playing it back. The narrative put forth by Atlanta and Atlanta PD is that his friends let him down by not giving a statement as to who killed this individual when they knew who committed the murder. By them being quiet, they allowed someone else to be arrested for the murder. He is saying that they should have told the police what happened. So when no one who from the group came forth and told the police the truth, Gunna felt it behooved him because it was his cousin being charged for the murder that he didn't do to come forward and tell the police what actually happened. Do you understand this article that we're listening to right now? They're painting a narrative that someone was murdered, right? And Young Gunna's brother was charged with the murder, but everybody hanging out that night saw who actually did the murder, but no one would give a statement to police. So guess what Gunna did? Gunna gave a statement, ladies and gentlemen. And he went on to become a millionaire rapper and a gangster.
I'm not happy that it happened, but you know what I'm saying? I'm kind of good to see that be on the outside looking in.
Kitchens is now a member of the neighborhood rap group SPC, known as Shady Park Click, like his cousin once was.
That's why it's come back to that street word, snitch. No one's want to be labeled as a snitch. I don't want to tell on him because somebody might try to come kill me or someone in my family.
Kitchens says Benton first lied to police because he didn't want to.
You hear what he said? It comes back to that street word, snitch. Gunna has telling you who he is. Gunna just exhibited the same characteristics yesterday. Did you hear what he said in this interview? Gunna said it comes back to that street word. What the fuck you mean? Street word, snitch. So what are you, Gunna? You not from the street, but you part of a rap group called the South Park Gangsters. But you talking about that street word, snitch. Contradiction.
Rat out another member, Clarence Carter.
Everybody, know. Like, the streets know. And so everybody looking at it like it was wrong because this man would let my family member, you know what I'm saying, go down for something he did.
Right. Kitchens claims Benton and Carter were both wearing red.
Now, did you hear that part? He said rat out another member. Just like in the case with the YSL, the individual that Gunna told on so that his cousin could go free, that's what they saying. We don't even know if the cousin went free. But the person that Gunna told on was in the group with him. So when you say no one said anything, these are a group of friends. Maybe it was an argument between these two guys. But one guy is already dead. And now we're going to lose two people. So Gunna told on his comrade in arms again. Y'all following this guy?
The night Jasmine Lynn was shot.
It was just a coincidence of how it was put out. Like, they actually had on the same exact color.
Okay.
He just had on a hood, and Devo didn't. He had on a regular shirt.
Kitchens believes that mistaken identity played a big role in this case. And he knows one thing for sure, that his cousin is innocent.
And it's not right because you think you have one in jail for the crime, but it's not the right guy.
We're making holidays merry.
So that's just a little backstory on Young Gunna, man. That's just a little backstory on Young Gunna.
What I was gonna say is just
We're gonna go back to the court. I really don't know what they're arguing at this point. I'm at 4 hours in. I don't know. Thank you guys for rocking with me. I truly appreciate everybody walking with me. I got peanut butter on my tongue.
are interested in that, but that might be something that should be considered and discussed. I'm available tomorrow afternoon, and I was going to see if that could be taken on Monday. For those particular, Monday is the 19th. Since we're going to be here all day, if we could utilize some part of that day, Ms. Rosenwasser, if you would be so kind as to send those who are left an email just outlining which particular witnesses you'd like to call on which days, that would give us some roadmap.
Absolutely, Your Honor. And we don't know how long everyone's going to take. We anticipate some days it may not take a full day, some days it will. We have one witness coming on Monday that can only testify. That's the only day she's available, but I think everyone else. We just ask that some of our people can be, if they're close by, could be placed on call. But other than that, we have everybody here, and we'll send out an order to the court, in order to be depending on which days on Friday I can do that.
Yeah, and the other thing I was gonna just point to everybody's, I know my order says the 19th through the 22nd. I think that we in the county are off on the 23rd, is that correct?
Yes.
And then we are also off on the 26th.
Yes, Your Honor.
Yeah, so I made a mistake as to that, as to our availability, so just adjust your schedules accordingly.
Yes.
All right, okay. All right.
So it sounds like they're going forth with the trial. Young Thug did not enter a plea, and Young Thug's attorney actually won the suppression. I have other breaking news. It's Perfect Timing Podcast. I got some other breaking news that come up because y'all know I'll be doing research while we doing the show. So I got some other breaking news that just came out. So y'all know during this podcast, I did a recap of my theory on the Takeoff murder. And shout out to Seti Nash. Seti Nash has got some more information that it looks like DJ Pat got bail. So the first thing we heard was that DJ Pat had got granted $5,000 from the court to do an investigation. Now, one of the things I said in previous videos is that I talked about Suge Knight having police officers. Kev Gills talks about grid, and Suge Knight having police officers who are blood members who were on death row's payroll as security guards and blood affiliates who had known Suge since his youth, who were friends, blood gang members, and security and affiliated through Death Row Records. These same individuals were involved with the murder of Biggie Smalls. That's what type of network you had at the $1 billion Death Row company. I put forth that potentially you have, and think about what you know about Jay Prince and mob ties in Houston. What Charleston White said about Dallas versus Houston. I say if there's any police officers who grew up in Fifth Ward, that they have ties to Jay Prince and mob ties. And this is why you see the investigation going the way it's going, and why the chief is insisting on this being related to a dice game and not doing any of the investigation that I've done. I think it relates directly to the fact that Jay Prince, his family, has influence on the police, which is not a bad thing, because if you're a prominent businessman, you would donate to the police. You may have donated to the mayor's campaign. There's a black mayor, there's a black chief. You may have assisted the chief of the campaign before. So it's highly probable that the Jay Prince family has ties to Houston PD, and it would make sense as business people as such, right? So let's go to the video where DJ Pat now has been given the bond. Now keep in mind, Young Thug and Gunna were never given the bond. DJ Pat is on camera killing a man. Is my microphone on? DJ Pat is on camera killing a man. Kyle Rittenhouse was on camera killing a man. They both received bail. And in this instance, we have a black judge, a black district attorney, black police officers in Atlanta, and all of these black individuals have denied Young Thug and Gunna bail. I think it's been against their rights. I think there's warrant of accusing prosecutorial misconduct. All right, let's go. Let's check out this video.
County courtroom. Today, the suspect in the high-profile killing of rapper Takeoff asked the judge for a lower bond. Investigators say Clark opened fire during a fight over a dice game, and they claim he planned to run to Mexico. Gerald Harris joins us live from the courthouse with more. Gerald.
Yeah, Clark has a $2 million bond. His lawyers are trying to get that amount reduced by as much as they can as negotiations continue with prosecutors and the judge. For several hours, Patrick Clark's defense attorneys and prosecutors argued in front of Judge Josh Hill about Clark's $2 million bond amount for a murder charge.
Today's hearing was fair, and I believe that it went well.
Clark's attorneys, pointing to the Texas state constitution, told the court that the bond amount is way more than what Clark's family could afford. Defense attorneys brought forth witnesses, including Clark's father and a bondsman, to discuss financial implications on the family and if there is a bond company that could handle the high dollar amount.
We feel comfortable that if we adhere to the judge's requests and orders, that he will set the bond as a reasonable amount that the Texas Constitution requires him to do.
Prosecutors argued they discovered video evidence linking Clark to being the shooter. Evidence allegedly showing Clark searched on his phone Texas laws surrounding friendly fire. Prosecutors also said Clark searched for fake airplane tickets and requested an expedited passport, which concerned the judge that he might be a possible flight risk.
I certainly understand the judge's position and the judge's concerns. It is our every intention to dispel of those concerns.
Judge Hill requested an affidavit of financial records of Clark. He also wants GPS technology in place that would notify the court of any tampering or violation of bond orders. Defense lawyers are asking for a $300,000 bond if conditions are met. Clark's attorneys also said that when this case moves forward, they're confident in a self-defense claim. Also revealed in open court today was Quavo, another member of the Migos, was part of the argument in the fight that led to the shooting. Defense attorneys and prosecutors say he has not been cooperating. In downtown Houston, Gerald Harris, KHOU 11 News.
All right, we
So that's the latest on the Takeoff and DJ Pat. He's going to get bond. He's going to get bond because it's a constitutional right. And unlike Atlanta, where it's really liberal, I mean, y'all, just y'all Democrats, liberals, only reason this is going the way it's going is because that's a red state and they're making them go by the Constitution. In a red state, you got to go by the letter of the law. Now, here, Georgia's supposed to be a red state, but it's turning blue, it's turning liberal, and all they doing is contorting the law. It's embarrassing. So he's going to get a bond, and it's his legal right. He should get a bond. It's his legal right, and as per Texas Constitution, he should be able to afford the bond. That's the right. Whether or not he did it or not, the burden is on the state, just like with Kyle Rittenhouse. You have to prove that he murdered Takeoff. The burden is on the state. You don't get to put him in jail and make him plea just because he's a black man. He gets to put on an adequate defense, just like Kyle Rittenhouse. So he's going to get a bond. DJ Pat is going to get a bond, and it's his right to get a bond, and he has a right to a speedy trial and to be able to put on his best defense. It's the burden is on the state. Do you understand what those words mean, that the burden is on the state? The state has to prove it. And this is the other thing that kept coming up in the Kyle Rittenhouse case. DJ Pat does not have to prove his innocence. That's not part of a murder trial. That's not what you see happening with Jeffrey and Young Thug. DJ Pat, by the law, does not have to prove his innocence. He is already innocent. And I think black people don't really understand how courts work. That's why I'm doing this. DJ Pat does not have to prove his innocence. You are innocent until proven guilty. And what the judge kept saying to Kyle Rittenhouse trial is that Kyle is innocent, and he is presumed innocent by the state, by this court, by this judge, and the burden is on you, district attorney, to prove that he has broken the law. That doesn't happen for black men in court. That hasn't happened for Young Thug and Gunna. It didn't happen for R. Kelly. It didn't happen for Bill Cosby. We are never presumed innocent. It's been a great show today. So DJ Pat is going to get bail. It's his right to bail. He has a right to speedy trial. He has a right to put on the best defense. That is a separate issue from the takeoff murder. We have to start separating our emotions. We did the same thing with R. Kelly. We interject our moral compass and our emotions into the R. Kelly and say it's okay for them to do the same thing that they do on the Jeffrey that they did to R. Kelly. Prosecutorial misconduct. They didn't give R. Kelly bail. They broke him mentally. They broke him financially. And they lied to the public about what they were charging him with. They illegally brought in witnesses. R. Kelly's trial is going to get overturned. They charged him with the Mann Act. They didn't charge Elaine Maxwell with the Mann Act. They charged R. Kelly with the Mann Act, and they charged R. Kelly with a RICO. But in Chicago, the individuals who were supposed to be in the RICO with him, in Atlanta, they got 28 people. You don't have a RICO of just one person. But in the case of R. Kelly, in the Chicago case, the individuals, the co-defendants in R. Kelly case were found innocent. So there's nobody else guilty in the R. Kelly case but R. Kelly. But R. Kelly is guilty of RICO and racketeering and running an enterprise, a network. But there's no network. The individuals who were charged with being the member of the network were found innocent. So how can R. Kelly have a racketeering charge when there's no network? This is how our rights, the black man don't get rights. We don't get treated equally and fairly in a court of law. We don't get treated equally and fairly in a court of law. And then, so what happens is some peanut head ass ninja will come on my panel and say, oh, you sleep with little girls? It's almost like they're so stupid and they could not contextualize my argument. So immediately they go to, oh, you like little girl. Like, did you hear anything I said? Same thing with Young Thug. Have you heard anything I've been saying this whole time? Oh, you got an issue with black women? No, black women have an issue and we need to get them help. I don't have an issue with black women. My wife is Sicilian. I don't have to deal with black women. I don't have an issue with black women, but I can see from my vantage point that black women have an issue. Meg Thee Stallion, this district attorney, the judge in the Meek Mill case, Nicki Minaj. We can keep going and going and going. These are the archetypes. Meg Thee Stallion. There's something going on here where these individuals are expressing this explicit hate for black men and black culture, where they're aborting babies by the millions and participating in scams to set up and kill and rob black men, and that thusly black culture. When academics says black culture is crime culture, this is what this produces. How academics can black culture be crime culture when black women are the most educated segment, unless you're separating black women from black culture? Are you doing that, academics? Because you're saying that in the same context as Meg Thee Stallion and Tory Lanez. So which one is it? Let's get a Meg Thee Stallion. Before I log off, can we get a Meg Thee Stallion update? So we've been doing a lot of updates. Before we get out of here, is there a Meg Thee Stallion Day 3 update by Marlo? Meg Thee Stallion Day 3 by that fine ass chocolate motherfucker Margot, star reporter Marlo. Ooh, that motherfucker, that's a chocolate fine motherfucker right there, boy. Oh, there she go. There she go. That's a chocolate fine motherfucker right there, boy. Star reporter Marlo. That is a chocolate fine motherfucker right there, boy. Okay. We're going to go to Marlo, but my boy is real succinct. We're gonna go Mo Gant. Gonna go Mo Gant. Nah, come on. Day 2. I need day 3. I need day 3, baby. I need day 3, baby. Let's go. Oh, it's day 4. Oh, it's day 4.
Here's one thing you need to do before you start your holiday.
Let's get us an update on this Tory Lanez Meg Thee Stallion. Let's get us an update.
Hey, you guys. Welcome back to my channel. It's your girl, Ebony. All right, you guys,
Shout
let's
out to
talk
Black
about the
T.
morning recap for the Tory
Fair
Lanez
use.
trial and how Kelsey Harris continued to flabbergast the prosecution. Now, you guys already know Kelsey Harris pretty much denied everything she told to prosecutors earlier today. And today in court actually made no difference, but the defense attorney was able to use the prosecution's questions against them. And we also finally know that Megan Thee Stallion did indeed have bullet fragments in her foot. So there is no doubt that she had bullet fragments in her foot. So let's go ahead and recap. So Kelsey Harris actually confirmed this morning that she told prosecutors in September that Tory threatened to pop her inside of the SUV. But she said on the stand this morning it was a blur and that her statement was a lie. She also recanted all of her recorded statement that she saw Tory point a weapon at Megan. Now, the DA is obviously upset and she keeps coming up with the fact that, look, you were granted immunity under the idea that you were going to corroborate Megan's statement. So the DA says this. She says, what happened between September and today? Then she said, has anyone from Tory's team contacted you? Kelsey said no. The DA says, in September, when you spoke with us, you gave us a lot of detailed statement about what happened, right? Kelsey said, yes. What happened between September and today that you all of a sudden forgot everything? She says, what happened? I told you what I'm going through. Postpartum and a death in the family. The prosecutor says, when you talked to us in September, you were being truthful, weren't you? Kelsey said, some things, yes. The attorney then says, did you fire the weapon at Megan? Kelsey said no. Now, after this happened, there was a lot of rulings with the judge, right? And so we did see the doctor come in, and the doctor did testify that they did remove bullet fragments from Megan Thee Stallion's foot. Okay. After that happened, this is where we saw the defense attorney finally get to cross-examine Kelsey Harris. During his cross-examination, he asked her if Tory Lanez had offered her any hush money or had paid her. She pretty much said no. She says, have we ever reached out to you, right? Has Tory Lanez ever reached out to you, asked you to give a statement or offered to meet with you? She says, the last time I spoke with Tory was when I picked up my stuff. And so this actually corroborates the fact that Tory Lanez did not pay her any hush money. We then saw the defense attorney say this, there was gunshot residue on your hands, right? She says, yes. Now, they didn't really go into detail of why that was happening. However, I do anticipate that now that Kelsey's done, we're pretty much still in the gray area of who popped Megan. Now, after this happened, this is where we saw the district attorney try to ask the judge to allow them to enter Kelsey's full statement from September. Now, unfortunately, the judge has not ruled on that, but the judge did rule on this. You guys remember, I told you that the defense team wanted to call Detective Stogner, the detective who was fired from the LAPD and is also accused of a botched investigation. The judge has approved their request. So now Tory's team is going to be able to not only question this outrageous detective, but also show that the entire investigation was botched. The judge also agreed that the defense attorney can ask Detective Stogner why he never pursued Kelsey as an actual suspect. This is actually looking very bad for the prosecution, but this is still not over. We still don't know who popped Megan. All right, you guys, I'm going to go ahead and play a lawyer reaction so that you guys can get a more legal synopsis. And once I have more information, I'll be back.
All right, subscriber only post. I'm going to do two. Here's the first one. So the first one, I'm going to catch you up on what happened in court prior to Kelsey taking the stand, prior to the doctor taking the stand. So the defense brought up a couple of issues where he feels like he's being treated unfairly by the prosecutors. First, so just housekeeping, let me also tell you this. The defense called back one of the police officers. He said, hey, this police officer is one of the prosecution's witnesses. I want on the record that he needs to be back here on Monday I don't know why he wants to cut back, but it's interesting because it tells you that the defense is definitely going to put on a case. A lot of times, sometimes the prosecution puts on their case, the defense rests, it goes to the jury. In this case, the defense is definitely going to put on a case. They'll probably have tons of witnesses. We're hearing Kylie Jenner, Corey Gamble, Tory might even go ahead and take the stand and testify. Then the defense was getting into this issue that they keep turning over discovery, like all the discovery and the witnesses, everything that you plan on introducing in trial has to be done 30 days in advance. That was not done here. So the defense's point is this is unfair. You can't spread this stuff on at this point. That's my Indian food. You also get to see that as part of the subscription option. And, the judge may said, look, I'm going to allow them to use this stuff. It's like an Instagram post. This detective who downloaded it from Instagram is going to testify and introduce the post. The judge is like, look, it was late, but I'm going to allow them to use it. I'll give you extra time if you need extra time to prepare. But a trial is a search for the truth, and I'm not going to deny them. Obviously, the judge is very pissed at Kelsey, just kind of being all over the place, lying, complicating the hell out of the trial. So he's going to let people ask her as many questions for as long as he wants. Morning session. We had the doctor testify. The idea that these are not bullet fragments in her foot, that's done. Forget about it. Those are bullet fragments. Every single person on that jury, if you ask me, believes that it was bullet fragments. How did they get there? That's the question. Kelsey took the stand. He was asked by the prosecutors, I don't know what the prosecutors were doing. If you ask me, it was a fumble this morning because they dealt with a witness who was hostile, not answering their questions, saying that she lied to them about all these statements where she incriminated Tory. And then that fumble was picked up on cross-examination. The defense attorney looks like he's on his way to the house. The defense attorney starts with the immunity piece. Okay, you've got immunity. You're only testifying once you got the immunity. Understood. Then the defense attorney goes into this idea that she's been paid off, and he does a great job of establishing the fact that she never made any statements to prosecutors in all of 2020, all of 2021. This happened in 2020. She only made a statement to prosecutors in September 2022. And the prosecutors are using all this evidence of alleged bribes. That stuff was years ago. So why would she have taken money years ago and then September 2022 not done what she's supposed to do when you take the money, which is lie for Tory? And to be sure, that's like the first 3 minutes of cross, because then we go into gunshot residue. You knew before you sat down with the police officers and gave your testimony that you had gunshot residue on you. Isn't that correct? She said, yes. Defense attorney came back and he used the prosecution's own questions against them. The prosecution had asked, hey, why'd you lie to us? Kelsey said, pressure. Defense attorney, where was the pressure from? Was it from Tory? Nope. Was it from anyone on Tory's team? Nope. Was it from the defense team? Nope. Was it from the prosecution? Yes. That type of sequence of questioning sits in a person's mind and goes, gee, I'm in a courtroom of law. It certainly seems like one side is winning. A lot more happened this morning. I'm talking about just a lot. The prosecution was straight up planting the seeds because I think there's a juror that they don't like and they're trying to get rid of him. There was an issue about the prosecution springing defense evidence. They're just like oh, hey, we got this text message. I just found it in my back pocket. I'm going to use it. And the defense attorney was going nuts. Gloves are off at this point. There's a lot of cordiality. There's a lot of decorum. People follow the rules. Nobody acts out. But the attorneys on both sides now, when it comes to hey, can we get by with this? No. I'm not okay with that. And, they're saying stuff kind of out of order, out of turn. People are starting to feel that trial pressure. That's how it goes. Nothing is decided. Everything is an open game. You got to be on your P's and Q's when you're taking it to trial.
Wow. What an update, everybody. Welcome back. Man, what a hell of a podcast today. We coming up on 5 hours. What an update. So they finished cross-examining Kelsey. They finished the prosecution finished their questioning of Kelsey. Then the defense got the cross-examining, and that was finished. They proved that Megan has bullet fragments in her foot. I'm sorry, I said in his foot. They proved that Megan Thee Stallion, or Michael the Stallion, has bullet fragments in his foot via the doctor who did surgery on her. So a lot happened today. And a lot of these cases is coming down to these black female district attorneys, these rogue black women in law enforcement. I don't know if anybody gonna talk about it, but I'm gonna talk about it. You guys, again, in the Tory Lanez case, you got Meg Thee Stallion lying, but you also have a black female district attorney who's been rogue and now who's being put, just like in Atlanta, all the misconduct and all of the sneaky things that they've done in order to get this indictment is coming out. And they should be embarrassed. They should be embarrassed. They should be embarrassed. Let me see who else. Let me see if I got that bad thing. You know I want to see that bad thing. You know I want to see that bad thing.
This right here is one of my 18.
Her big bad chocolate. She always eating too. Big fine motherfucker. Always eat. Look at her. Got something in her mouth. It's always got something in her motherfucking mouth. She got a mouth fetish. This is a bad motherfucker, boy. She always got something in her mouth. Has anybody noticed that she keeps something in her mouth?
I'm not telling them right quick that ain't shit changed, but today.
Hold on.
But today.
Hold on. Look how she start. Look how she start. Look at that bad motherfucker right there. Look at them lips. She got the titties covered up today. That's a bad motherfucker right there.
Before you long. So
that's
hurry up.
They probably
didn't tell nobody. I'm not telling them right quick that ain't shit changed, but today. But today. Because see, this is what I gotta tell y'all. We done went back up in this courthouse. So I'm gonna give you a quick rundown because I gotta go, right? Gotta get back soon. Okay? Say hey to Chanel.
Hey.
Say hey to Cupcake.
No,
okay.
You know, people keep asking me. Mwah.
Thank you.
I said I'm at the recording.
Okay. So this is what I want to tell y'all. These beautiful young ladies are being so kind and so sweet to me and so hospitable, and I appreciate that so much. That's number one. But number two, the doctor came in. When we came back in, they didn't even want to start with Kelsey's ass because I guess didn't nobody want to get no fucking migraine. So they started with this doctor. Now y'all need to go find this doctor and see if he's single. He done went to school. He done came out here after graduating and he worked at Cedar Sinai. That nigga is making some good bank. He was well dressed. He was an Asian man. Who like Asian niggas? Y'all need to go see about that doctor. His name Dr. Harambe, some shit like that. Dr. Harambe, Harando, whatever. Y'all need to, I got it in my notebook. I'll tell y'all his name later, but y'all need to go look him up and see what he hit for. But anyway, he got on the stand and it was confirmed that there were, fragments, metallic fragments, which would mean bullet fragments that went into Megan's feet. We saw the x-ray. They put that x-ray up there and it took up the whole damn screen how big her foot was. They put it up there and the bones was just all over there. I was trying to find the bullet fragments because all I was seeing was some long ass bones. And I say, okay, I can see it. The people had to give them a pointer so that they could point to it so we could see it. And I say, oh, right there. So now we know for sure that is what was in her foot. Now, are the bullet fragments missing? That's still the question. It was documented that they are missing. But we did see I love Chipotle, bitch. We did see that we did see the x-rays. So he talked about the procedure. But let me tell you something key that he said. That he ain't know nothing about no damn nerve damage. People were supposed to have nerve damage and couldn't walk good and had to go to physical therapy. But he said, nah, he don't know nothing about no nerve damage. He said they cleaned it. They opened it up a little bit more to make sure they got as much out as they could, patched her back up and all of that. But he said no when they asked him about nerve damage. No. He did not talk to her when she got there. So we'll see when it comes to that other report. Remember FedEx came out and there was a Dr. Lafredo that treated her for glass, quote unquote, all of that shit. That'll be interesting if that's even brought up. But maybe they don't even want to toy with that because of the fact that we know, like, okay, well, the bullet fragments were in your feet. So, whatever. I don't think they're pressing too much about the glass. We know she said glass and all of that shit, but child, whatever. So it was confirmed that there were metallic pieces in her feet. They showed x-rays of both feet. They showed us the different, pieces in the feet and told us, what the fuck they wanted to do and all of that, the procedure. It was very quick. It was very to the point. And we got through that. Here come Kelsey and what they called her husband. Kelsey, you done went down there. He done made an honest woman of you, and you ain't tell nobody, so we can congratulate you, bitch. Congratulations, girl. So, Kelsey say, you know, baby, this a household. This is of God. And so they got Kelsey back on the stand. They say, Kelsey, do you understand, like, what the hell is going on? Like, you know what you told us in September, bitch. Okay? I'm just sitting up here like, bitch, wake me up when September ends. I'm sick and tired of hearing about motherfucking September, bitch. Do you want to go to October? Do you want to go to November? Do you know that it is December? I'm tired of September, bitch. So they go back to September. Kelsey ain't changed her story. Kelsey say the same thing that she said yesterday. I don't know. I did not see him shoot her. I don't know. They don't want to accept it. They don't want to take it. Bitch, eat that shit up. Look, go like this. The prosecution, take a bite. Eat it up. Ain't nobody want to hear shit. So then, finally, Kathy Ty, her hair so motherfucking stiff that she wants to go like this. She couldn't. So she just stood there. She was like, look at her, it went like this. And she turned with her hair. And then she went and sat down like, child, I'm done. Whatever. I'm done with my questioning. And so the defense got up there. And he said, Kelsey, you know, you understand about your immunity deal? Do you understand the terms and conditions? Do you understand you can still perjure yourself? And so she was like, well, let me get some clarification. Let me talk to my lawyer. And so her and her super duper cute lawyer, he is the cutest little old man. You know how you'll see an old man and be like, I know you was a cute kid. He looked like the cutest little old man. I know he be getting his kids good Christmas gifts. They probably got them little college fund and shit. But he talked to her in the back, and when she came back out, it was like, okay, well, yeah, I understand, you know, the terms and conditions and all of that bullshit about my immunity deal and what I got to do. I can't lie up here. He say, okay, cool, we got that established. She say, did anybody from the defense come to you, harass you, bother you, do anything like that? No. Let me get to the nitty gritty because it's 1 o'clock. They said, did the prosecution take an interest in talking to you before you found out and before they found out that we were leaning as the defense towards pointing the finger at you because there was gunshot residue on your hands? Baby, it then came out that they wasn't trying to talk to her until they found out that, okay, well, the defense is going to say you did it. So what you want to do, this will help you. That is the premise that we going under. I told y'all ass yesterday, Kelsey's answers sound just like Megan's. It was like, it was the same thing. It was the same thing. I heard what Megan said. A lot of Kelsey's answers in that interview was the same shit. So I thought that it was like some, They said, well, who did you feel pressure by? Did you feel pressure by us? Did you feel pressure by the prosecution? She said she felt pressure by the prosecution. She said she felt like she had to go in there and talk to them in September. That's what she said. They ain't want to hear that shit. The white man, he handsome, that little Barbie doll Ken looking nigga. He say, when everything got done with, he said that is not okay. You know, for me and my daughter to be brought up and our integrity to be questioned and all that kind of shit like that. Bitch, she was mad, but bitch, I wasn't giving a fuck because at the end of the day, she said what she said. And y'all trying to sit up here and make Tori be the aggressor. Kelsey said,
I didn't have health insurance, not because I didn't want it. I worried it was too expensive, and I was having a hard time paying our other bills. But now, for the first time in our lives, I can do both. Covered California makes health insurance easier in every way, with financial help for millions of us and free assistance to compare your options. Covered California, this way to health insurance. Enroll by December 31st at coveredca.com.
I ain't talked to Tori since I picked up my bags from the hotel outside on July 11th, 2020. No, 13th. July 13th, 2020. She said, I ain't talked to him since then. So all of these theories about the money, she said, let me make it very clear. They said, wipe your nose. That's that contour. The filter gonna make it look crazy. She said, let me make it very clear. She said, I saw something on social media already from Megan people. She's talking about the shade room. The shade room want to get a comment from Alex Spiro because he's sitting up here talking about it's clear that she's been compromised. Why in the fuck wasn't she compromised when she sat on the stand and said that Megan got an apartment for her? If Tori had got an apartment for that fucking girl, y'all would have said that he was paying her. But Megan did. Megan set her up with an apartment is what the fuck her words were. So why in the hell ain't that bribery? Why that can't be used as bribery? Well, I put you up in somewhere to stay. So what you gonna do? You want a roof over your head? How you know? Yeah. So while they sitting up here trying to paint the picture that Star Peterson will sit up and offer her all this shit and try to get her to say something, she said, I have not talked to her. I have not talked to her. So, or I ain't talked to him rather. So what's the deal, Pickle? So at the end of the day, these hoes on some shit. We're gonna come back to cross-examination. Kelsey got the same story, and it ain't changing. It ain't changing. Throw this shit in the garbage can. That's what I say. Throw all this shit in the garbage can. Don't nobody want to hear this shit. Y'all niggas in LA do not be seeing thick ass bitches because these niggas is honking at me because they like these motherfucking thighs, bitch.
Them Houston girls is different, baby.
So, I'm gonna talk to y'all later. That's what the fuck is going on. They had the doctor come up there and talk about, yeah, it was a debridement, and they picked it up out of there. And yeah, but this is not about where you shot. This was about who shot you. So, girl, okay, like this is about did Tori shoot you? Because that's what you said. Y'all trying to lock a nigga up for shooting you. Okay, then that cannot be proven in the court of law. Let's cut the shit. So now they want to play the whole interview from September. We don't give a fuck. We don't give a fuck about the interview. Kelsey say she lied. Do you understand what she's telling you? She said she lied. Y'all want her to say something different so bad because that's what you said. You know, that's what you want it to be. Let it go, ho. That's not what she gonna do today. You ain't picked up. You ain't get the motherfucking memo. We 2 days in. We too deep to ever lose it. She said no. It's giving court rape. Because at the end of the day, I'm just not understanding why y'all keep on badgering this girl about the same shit. And I just really want another juror removed. There was a juror that came in with her thong showing her the top and midriff. I wanted her out the other day because she looked like she could be a hottie. And then now we got the coughing monster. Okay, I don't know what the hell is wrong with him. Every time we're trying to hear what the hell going on, he want a motherfucking cough. Is he a plant? Why in the hell do you want to sit up here and cough every time we're trying to get to the business? I don't like that. So, people, I am signing out because I didn't even really get to eat my Chipotle. Please, I had got Rubel. Ooh, can you mix it with some Coke, half and half? Ruby and Coke. I want all that dark shit. I want all that dark shit mixed up half and half. So, yeah, the shit dumb. The shit dumb to me. I feel like we need to get done with this shit. Yeah. Academics, I see you in the comments, but I'm going to be able to talk later because we're about to have to go back in. But basically, I'll tell you what happened real quick. The doctors got up there and talked about, the doctor got up there and talked about the procedure that he did, the debridement and what was, in her foot. We saw x-rays. It took up the whole screen. I thought it was Bigfoot, and it was a sighting. I was about to call that nigga from Ancient Aliens, but then they said that was Megan Foot. And then Kelsey got up there and she ain't changed a damn thing. And she said the prosecution been pressuring her. She felt like she had to go up there and get into it. Okay? Talk about it.
Oh. Yeah, you got 3 bites. I'm your assistant.
Hey.
What's up?
Hey, listen. I really want you to. I want you to eat your food and everything. I want you.
Yeah.
But no. I was listening. I was hearing the whole thing. I ain't gonna lie. This sounds. Yo, what happened with the jurors getting dismissed? What's going on? Drunk.
Somebody came back, look it up. I ain't gonna say drunk, but yeah, alcohol.
Really?
I'm trying to go back high.
Hey, you know what's so funny? It's crazy that Kelsey saw the shit that got posted on Shade Room. I mean, she on social media. I thought today she was going like buckle some social media pressure because there's a lot of women that are saying, "Yo, fuck all that. You got to take your best friends back. Your best friend probably did this for you. yo, what are you doing? I thought she would have, but look like she doubling down, right?
Not only doubling down, she said the prosecution pressured me, not Tory. Not Tory's defense. I have not been harassed by them or nothing. They said, did you feel pressured by the prosecution? She said, yes. That white man was pissed the fuck out. He's mad.
Did they try to, like, you know, pursue any more angles when it came to, hey, have you talked to Tory since then? Because I know she said she didn't.
The prosecution was asking questions like that. She said she don't. Kelsey even told the prosecution, I don't even remember what I told you yesterday.
You're
Lord. Lord.
She said that?
Yeah, they was asking her about shit she said yesterday. She said, I don't recall. She said, I don't remember. Yeah. Yeah. Oh, this like damn with this filter. I'm gonna go like this. That shit look ugly. All right, y'all
Now
listening.
you good. Now you good, girl.
I look like a grease ball in that.
I hear you out there taking LA by storm. They can't deal with you out there.
No, they trying to put me out every goddamn day. They said put my titties up. They don't want to see my titties. They don't want to see my motherfucking legs. Said no one ever. The fuck?
Damn. They must say it's probably one of the attorneys or one of the jurors that's, you know what I mean, you hypnotized.
Maybe that's what it is. Maybe that's exactly what it is. No, they be seeing we go live, and they be seeing that these people ain't jaded by this bullshit that's going on, and they want to stop to this shit.
Hey, which damn juror got a goddamn thong out? What the hell? What's going on?
Yeah, they say that it's rumors circulating in the hallway that the juror was liquored up. They say
the thong?
No, not her. She's still sitting up there hanging on for another day. And some pieces of clothes. Child. And let me tell you something. It's this old lady, somebody grandma on the jury keep falling asleep, child. She keep on nodding off. I say, damn, this ain't Judge Memphis. This hoe act like she's sitting at home in a fucking recliner. I want her off the jury.
Hey,
that
listen,
bitch better not find my nigga guilty because she had a dream. I'm not playing with her.
Hey, here's the thing. She probably done heard enough. She ready to go to sleep.
She have heard enough, and I didn't heard enough too.
She heard enough.
We need to throw this case out.
Hey. So pretty much the surgeon, like you know, kind of giving his testimony, that didn't do anything because that don't even matter, really. It don't even matter because this ain't about did she get shot. But let me tell you something important. He said there was no nerve damage. He didn't know about any nerve damage. So all of this I'm interested to know about the physical therapy and the couldn't walk claims and all of that, because he made it seem like they patched up, cleaned up. She was kind of good to go. She could have some residual pain, but the defense said, does she have nerve damage? And did you observe nerve damage? He said, no, she did not have nerve damage. So how you couldn't walk? So pretty much that kind of corroborates what we all see when, you know what I mean, Meg was hitting some of the illest twerks after that.
Yeah, like she was bouncing that ass for an icy chain. Sure was. We seen
God
her ass.
damn. Yo, so right about now, what's the temperature with the defense? Are they going hard at her? Are they taking it easy?
The defense, I think it could have came off as though he was being very stern, but he was just making it very clear. They were being accused of robbing this girl and being accused of paying her off and stuff. So he wanted to make sure he came in strong, making sure that she understood the immunity deal, that she understood what perjury was. And he was very concerned with asking, did you meet with Tory? Have you talked to Tory? Have we ever harassed you? He said, have I ever, or anyone on my team, ever reached out to you in life, you know, and tried to talk to you or whatever? She said no.
Did they ask it when's the last time she's talked to Meg?
Yeah, and she said that she ain't talked to Megan or Tory since the incident. The last time she said she talked to Megan was when Megan helped out for the appointment or for a place to stay, whatever it was. Oh, damn, it cut out.
You hear me now?
Yeah, I can hear you now.
Did they ask if anybody from Rock Nation, anybody who might be affiliated or associated with Meg, may have reached out to her? Because it seemed like she's saying I didn't really want to come and tell y'all them lies before, but I was getting a little pressure from y'all, so that's why I said it.
Right.
Did she
They
put any
didn't. They did
finger
not.
on where
They did not say Rock Nation. They did not say Rock Nation, but they did say, "Did you feel pressure by the prosecutors?" And she said, "Yes." She said, "I felt threatened when they came to my home, and when I was told that I needed to come in, like I had been subpoenaed." And they was like, "Well, that was for the subpoena. What about coming in and talk to them?" She said, "I felt like I had to come in and talk to them." And he said, "Did you feel like you had to come and talk to them?" He said, "Did they take any interest or reach out to you before 2022?" She said, "No." So the defense painted the picture that they only contacted you after they found out and told you that we were gonna press you. We was gonna put it on you, that you're the one that shot Megan. They say, "So did the prosecution come to you under the premise that you better come speak to us because this is what's gonna help you because they gonna say you did it?" And the answer was yeah. She felt like she had to go in there and talk to them because she felt pressured, and that she did only talk to them in September after she was made aware of the fact that they were going to accuse her of it because she had gun residue on her hands. They confirmed that Kelsey did have gunshot residue on her hands.
Wow. Hey, by the way, that's a big deal. So you telling me they were prepared for this case for over a year, and they didn't, and they didn't really care about what Kelsey was gonna say until they realized that Tory
they thought this shit was sold up.
Man.
Yes, until
some
they
sloppy
like,
shit, man.
It is sloppy.
This holiday, master your kitchen with Wayfair. Keep it fresh with colorful cookware. Whip up holiday treats with ease. Slice and
sloppy. They said, "Oh," basically it was like, "Oh, Tory might have a way out of this." Then they went over there to Kelsey to talk to her. And then Kelsey went. They said, "So you went over there because you felt like that's what you needed to do because the finger was pointed at you, basically." And so she was trying to skirt around it, like, "Well, I don't know why they wanted me to come in," but he finally asked her the right way, and we got our answer. Them people only got interested in your ass when they found out that, hey, we got another person that we could put this shit on. Yeah, she got gunshot residue on her hands. You better get up in here and do something, girl, before you go to jail type shit. I'm not quoting verbatim, but it was type shit like that. So the picture have been painted.
Kathy running a loose ship over there.
Yeah, the ship going down, baby. It's Titanic.
Yeah, nah,
this what this is.
Nah, this is bad. What are we expecting to see for the rest of the day? It's only. What are we expecting to see for the rest of the day? Is it only Kelsey, or is there any other thing?
I pray to God we can wrap up with Kelsey, but the judge did say we gonna be done at 4. We will be done at 4 o'clock. There was one time where they said, "Can we approach the bench?" The judge said no. He's so tired of this shit. I think he's tired of Kelsey. I cannot speak for nobody, but every time Kelsey get up there and shoot with this shit, he don't want to hear nothing. They got issues. They want to present evidence that they ain't shown at the right time. When we came into the court, they was talking about no, they need to be responsible for showing this shit and not doing it the proper way. They need to be held responsible. So if people was upset this morning, and Kelsey came in with the same shit.
Is the judge coming off like impartial though? Like, you know, like they're just trying to make sure we get a good trial, or are there more?
I feel like the judge is, if it was a 100 scale, I feel like the judge is 60% fair. He be letting, to me, too much shit slide when the prosecution want to let somebody answer something, and when Tory side object to something, it be like, "No, go ahead." But he kind of be letting them do their little thing too and ask their questions. But I just personally feel like it seemed like he be harder on the defense side. A little bit, nothing crazy, nothing that would make me feel like, damn, do you think he guilty? You know, but I feel like, you could ease up a little bit now. Come on now.
No. This is good info. Listen, I'm glad her testimony is about to wrap up, because here's the thing. I want to know, what is Kathy Ty about to do after this? She finna
go work at the post office. I'm gonna give her an application.
Yo, I don't know what other rabbits you can pull out the hat. Like,
ain't no more.
What is she gonna do?
Take her ass down that motherfucking hole like Alice, see if she can chase that motherfucker with that damn watch he be having in his pocket, because they no more rabbits, baby.
Hey, listen, I keep saying, let's score the trial as the day and as time goes by. what I'm scoring it right now, I think Tory's up a couple rounds, and
Yeah.
we didn't get to his witnesses yet. And to be honest with you, I don't think this is a reverse course at this point.
Yeah. I'm on the city bus. We doing some real local shit.
Real LA shit.
I'm on the city bus. The sound had cut out. I'm in the ghetto. Whatever.
Oh no, that's all good. It's all good. You like it out here in LA?
It's all right, but you know, I've been doing this shit, so I ain't been able to really just like see it. But yeah, it's cute. It's nice. They're selling t-shirts, shit, perfume, hot dogs, and chips on the side of the street. I say, okay, gas station. Okay, I'm trying to see if I can find me a wig. Child, maybe a bitch can put that hoe on my head on the sidewalk. I don't know.
Hey, by the way, if it's worth anything, yo, my whole audience, they all fuck with you, yo.
It is worth something. Hey, chat niggas.
Yo, they think you're a beautiful black queen. They love the sauce. They love the accent.
Yeah.
They love how you giving it up out here.
Yeah. Okay, I love y'all too. Y'all send me $20. Love you.
Yeah, no, hey, yo, please, anybody watching, listen, please support her in any way. You know what I mean? Some of y'all dudes maybe should answer y'all back if y'all, show cash out some love, man. You feel me?
Yeah, I appreciate you, academic, so much.
No doubt. Listen, I'm gonna let you go. That you get some time to, get back in court and everything. As soon as you get back out, we'll be back on. All right?
Yeah. Okay. Talk to you soon.
All right.
The second you have a kid, it's like your heart is living outside.
That channel was horrible on the commercials. They talking about 12 seconds. They be back in 12 seconds on the commercial. And it was the end of the damn video, man. Some YouTube be robbing, man. YouTube is straight criminal. So that was a hell of an update on Tory Lanez. That was a hell of an update on Tory Lanez. I hope y'all enjoyed that. That was a hell of an update on Tory Lanez. Just a recap for anybody just coming in. Kelsey is done on the stand. She recanted everything that she testified to on September 16th. They tried to reinstate what she said on September 16th. We haven't got a ruling on that, but it doesn't look good for the prosecution. Looks like Young Thug and are still in court. That's an 8-hour live stream. I just took a look over there, and Young Thug is still in court. But he's had a great day. Yeah, he's had a great day. He's been successful in court today. He had a great day. He was successful in court today. I'm attempting to share it. I guess it's done. Yeah. Look like the live stream is over. So look like court has concluded for Young. Oh no, still live. It's been a long day in court. So they still live. So they still live. It's been a hell of a day for Thugger. A hell of a 2 days for Thugger, right? You guys, thank you for rocking out. I'm tired as hell right now. Oh, these live streams, man, I don't know. It takes a lot out of you doing these lives, these long lives. I gotta pick up my son, and I need to go get in. I gotta go stretch my legs, man. So I thank you guys for rocking. I don't know when I'll be doing. Who's on the stand right now? Who's on the stand right now? Is that a police officer? Is that the district attorney? Who's on the stand? I wonder if they still trying to get it dismissed.
Motions, because I've kind of run out of. Okay.
So we don't know who that is on the stand right now.
Miss Hilton is going to be right back. So you want to talk to them? Adrian, do you want to talk to this?
She's coming right now.
What do you need us to do? Hello?
Hello, yes, so my name is Ade, I'm from Core Technology. I would like you to please reshare your screen so that the sound can come out properly. Please stop share. No, they can follow my direction.
Just one moment. You need us to stop share.
Yeah, for a quick yes.
All right, okay.
Good, so next time you click on the share screen button, please, there are two check boxes underneath that. One of them says share sound.
They would check and we will check them again if you'd like.
You were checked?
They were checked.
Oh, okay, thank you.
Now, we can take out and optimize for video clips since that's not.
You can leave that. That doesn't matter.
So it sounds like they trying to get the audio together. So it looks like we still got some good court going on here. I'm gonna shut it down though, y'all. I mean, I could leave it up and playing for you guys to watch it, but I want people to rewatch this, and we already have 5 hours, so I'm not gonna leave it up. We will come back to this. If any bombshells come out of the late day in testimony, we'll come back to it, and then we'll break it down and react to it like that. Thank you guys for hanging out. Have a good day. Be blessed.